So it's time to begin the forum. Greetings from Tokyo. I am Teppei Kanezaki, attorney at the Minister Secretariat, International Affairs Division of the Ministry of Justice of Japan. I will be acting as program moderator today, and it is my pleasure to welcome you to the 2022 Tokyo Forum on Dispute Resolution. Without further delay, we will proceed to opening remarks. The first opening remarks will be delivered by Assistant Vice Minister of Justice, Ms. Noriko Shibata. Ms. Shibata oversees basic policy planning and coordination of all matters concerning international affairs and human rights in the Ministry of Justice. Could you come to the podium?
Sorry. Good afternoon, and my greetings to distinguished participants here with us and joining online from around the world. I am Shibata Noriko, Assistant Vice Minister of Justice of Japan. It is my pleasure to convey my remarks at the opening of this forum. The Ministry of Justice of Japan is very pleased to be able to co-organize with UNCITRAL and ICSID once again this gathering 2022 Tokyo Forum on Dispute Resolution to discuss the various key issues in the field of international dispute resolution. In contrast to the forum held last year, which was held completely online, we are delighted to have here in Tokyo Ms. Anna Jobambure, the Secretary of UNCITRAL, Ms. Meg Kinia, the Secretary General of ICSID, distinguished speakers and participants. We are also extremely happy to have distinguished speakers and participants joining us online from around the world. This hybrid forum is indeed one of the uptakes since the outbreak of the pandemic. Let me begin with the consistent line that the Japanese Ministry of Justice adheres to. Dispute resolution mechanisms are cornerstones of a rule-based international order. It cannot be overstated that they are essential in ensuring the rules and agreements are duly performed and that justice is properly served. It is often said that there has been a steady and growing trend towards digitalization, that this trend has been accelerated by the pandemic. It does seem to hold true that this trend continues to pick up speed. As compared to last year when COVID measures were applied rigidly, however, we are now seeing those measures being relaxed. Circumstances continue to evolve with speed, which makes us believe all the more that monitoring the changing landscape of dispute resolution is essential. In doing so, we are very honored to co-organize with two key intergovernmental organizations in the field of dispute resolution, namely UNCITRAL and ICSID. As for UNCITRAL, as you may be aware, Japan has a particular interest in the project on the stocktaking of developments in dispute resolution in the digital economy. This project was proposed by Japan at the Commission session in September 2020 and approved by the UN General Assembly in December 2021. We are very pleased to see that the project has been steadily making progress under the leadership of Ms. Anna Jobambure. With thanks to all the support extended to this project, the Ministry of Justice of Japan is pleased to continue to fund the resources necessary for the implementation of this extremely important project and looks forward to discussing the progress achieved at the Commission session in 2023. We are committed to supporting the project in any way we can, and I very much hope that the discussions to take place today will contribute to the stocktaking activities. And regarding ICSID, I would like to begin by extending our congratulations on the adoption of the amended ICSID rules and their subsequent taking effect in July this year. Japan participated closely and actively in the rules amendment project, and having contributed to the amendment process, this achievement was special also for the Ministry of Justice of Japan. We are pleased to see principles and key elements of dispute resolution appropriately reflected in the amended rules. Mindful that it may be premature to draw any conclusions, we are very much looking forward to the discussions tomorrow on how the changes to the rules have had or expected to have an impact on investor-state dispute administered by ICSID. In conclusion, I wish to extend my sincere wishes for fruitful discussions to all speakers and participants. Thank you very much.
I thank Ms. Shibata for her remarks. Next, we have Ms. Anna Jobambre, the Secretary of UNCITRAL. It is an honor to have Ms. Jobambre here with us in Tokyo today. Ms. Jobambre is the 9th Secretary of UNCITRAL since its establishment by the United Nations General Assembly in 1966. Please, you have the floor.
Thank you very much, Assistant Vice Minister of Justice, Madame Noriko Shibata, for your kind words of welcome. And thank you also, Teppei-san, for your kind introduction. This year's gathering, ladies and gentlemen, is special. Delivering my remarks online from Vienna in December last year, I expressed my hope for a face-to-face reunion with colleagues at the Japanese Ministry of Justice, at the Ministry of Foreign Affairs, as well as an opportunity for exchanging views with professionals and practitioners in Tokyo and around the world. A year later, I'm delighted to be here in Tokyo to be able to do precisely that at full after a long-awaited hug and handshake. Welcome to all participants here in Tokyo and connecting online from different parts of the world, and many thanks to the Ministry of Justice of Japan and to ICSID, our friends and colleagues, for organizing this gathering together. As is well known in the well-known John Lennon music, "So This Is Christmas," we gather here once again for the annual Tokyo Forum on Dispute Resolution to anchor new approaches to the core principles of due process and fairness. And we ask ourselves, after 1 year, what have we done? Where are we at? And where are we going? There is a lot to be discussed. As most of you are aware, the United Nations Commission on International Trade Law, UNCITRAL, is an intergovernmental body which forms part of the General Assembly of the United Nations, and it has a mandate to progressively harmonize and modernize international trade law with a broad understanding. It's a legislative body with a focus on developing and preparing international legal norms. It was as proposed and funded by the government of Japan and formally approved during the Commission session of 2021, the UNCITRAL Secretariat continues to be provided with the mandate and now the resources necessary to compile, analyze, and share information on the latest trends regarding international dispute resolution through the project on stocktaking of dispute resolution in the digital economy. Since its launch in December last year, the project has been making steady progress with a view of laying the groundwork for possible future work on updating UNCITRAL texts or developing new ones if necessary. A special thanks goes to the Ministry of Justice of Japan for funding this very important project. The Secretariat is extremely grateful. As you may recall, at the time when it was launched, the expectation was that the outcome of the project would contribute to UNCITRAL's work in discharging its mandate as a legislative body, particularly in the area of dispute resolution. While the project was broadly supported, to mobilize the resources available effectively and efficiently, further scoping exercises were needed before embarking on concrete activities. To this end, UNCITRAL Working Group II, which deals with dispute resolution matters under the guidance of its chair, Andres Hanna, whom I salute, having come from so far to join us here. Working Group II, as I was saying, held a colloquium at its spring session this year to discuss relevant legal issues arising from the digital economy and the scope and nature of possible legislative work. Specific topics for the project were identified, and the discussion stressed that the project should give particular attention to the disruptive aspects of digitization in dispute resolution, especially those with respect to due process and fairness. The discussions were also suggestive of the focus that should be given to the enabling aspects of technology, particularly as far as the impact on cost and duration was concerned. This July, having considered the Secretariat's report of the colloquium, the Commission noted the timeliness of the project and the increased use of technology in dispute resolution. Of course, we've all gone through the Zoom and other technologically enabled features of dispute resolution through the COVID pandemic. And the increased use and the request was made to the Secretariat to continue to implement the Stocktaking project and report on the preliminary findings to the Commission in 2023. As I speak to what we have done this year, we would like to also express our thanks to the government of Japan for taking part in the Commission session and all the working groups of UNCITRAL, where it is particularly active. And I should also, of course, particularly mention here working groups 2 and 3, where the views of the Japanese delegations are broadly shared and well respected. We also wish to note that this July, the Commission welcomed 5 additional members to UNCITRAL, making a total number of 65. And we're seeing by doing that the result of the coordinating role that Japan played in the enlargement of UNCITRAL membership. The Commission will be welcoming another 5 members in 2025. It is certainly not that we gather here to simply reflect on what we have done this year. We must also chart the way forward to achieve concrete outcomes. In response to the Commission's request, the secretarial report to the Commission for this year will be on the preliminary findings. In doing so, we will continue to conduct research and organize discussions to seek inputs from different regions to ensure that the perspectives from different parts of the world are properly reflected. And we're delighted to kick off this world tour that is going to keep Takashi busy for the months to come here in Tokyo, which will be followed by discussions in North America, in Latin America, in Europe, and in Africa. All around the world, we will address the questions: what are the technological means, both new and conventional, that are used? How have they changed the landscape of dispute resolution? How has practice adapted to the changes? And is there a need to update or develop new rules or standards or guidance? Finally, let me add my wishes for fruitful discussions. And with that, I conclude my remarks. Arigatou gozaimasu.
I thank Ms. Jobambre for the remarks. We are delighted to have you. We are also honored to have Ms. Meg Kinnear, the Secretary General of ICSID, with us today. Ms. Kinnear was first appointed as Secretary General in 2009 and is in her 3rd term as head of the institution, which administers more than 300 investment arbitrations each year. Please, you have the floor.
Thank you for the kind introduction. And thank you very much, Vice Minister. We're very happy to be here today, and to see my friend Anna again today is lovely as well, and to see so many friends in the room. It's an honor to join you, and so lovely from my part to join you here in person again instead of remotely as we ended up doing last year. This is a delight. This forum continues our long and very collegial relationship between Japan and ICSID. As you may know, Japan was one of the first countries to sign the ICSID Convention, and it ratified it in 1967. So Japan remains one of the most long-standing members of ICSID. Okay, gonna make life easier here. Over the years, we have benefited from the participation of Japan on our administrative council, and we've also benefited from the involvement of a number of Japanese arbitrators. A number of you will know Professor Yasui Taniguchi, Professor Hiroshi Oda, and Ms. Yoshimi Ohara, who is here today, have all been members of the ICSID panel who have participated in cases. And I know when I've been here, some arbitrators have told me they also took courses from Professor Taniguchi and remember him well. So he is a part of arbitration history as well as at ICSID. Since our establishment in 1966, we have done more than 70% of all the world's known cases. And most of these have been arbitrations, but we have also done conciliation, mediation, cases under the UNCITRAL rules, ad hoc cases, and even the occasional state-to-state case. So the docket has been varied. We have seen an increase in the number of cases brought by Japanese investors. And in fact, since 2015, we've had 5 cases that have involved Japanese investors invoking the dispute settlement mechanism under ICSID. We've seen as well in August of 2021 that Japan renewed its panel of arbitrator nominations, and we were most pleased to receive that. We also have another connection with Tokyo, which is my colleague Jerry Fisher, who is based here and has been here for about 2 years now. And I think it's wonderful that she is here and able to speak with you. If you need immediate ICSID advice, you call Jerry because she'd be more than happy to share her expertise. I also want to thank the Ministry of Justice because as of January 2023, we will have a Japanese council joining the staff of the center. And I think this is our first Japanese council, so that will be an important moment for us to mark as well. The final point I wanted to make is to thank the Japanese government for the very active and very constructive role they played in the ICSID rule amendments. We will be talking about this tomorrow, but it is something, as you know, we worked on for about 5.5 years. It was adopted by our members in March of 2022 and came into effect in July of 2022. The most important thing that I think about these amendments is not just that they were adopted, but by a consensus of 85% members in favor and no member voting against them. And I think this is a wonderful basis for going forward in the future. I think they are truly state of the art and represent a consensus among international milieu. And so I think this is a wonderful place for us to have a discussion. So I look forward to today's discussion of remote materials, certainly something we've been living daily since the pandemic, and tomorrow to talk more about our amendments. I wish you a wonderful conference. Thank you.
I thank Ms. Kenya for the remarks. It is a great pleasure to have you. Ms. Kenya will be on stage for session 2 tomorrow. With this, we are now ready to proceed to session 1. Session 1, panel 1, will be moderated by Mr. Takashi Takashima, Legal Officer of UNCITRAL. Takashi, the floor is yours.
Thank you, Teppei. For our stock-taking purposes, we have 3 panels for session 1. As mentioned by the Secretary of UNCITRAL in her opening remarks throughout, we will be asking or discussing, in essence, what is going on with the use of technology in dispute resolutions, what are the pros and cons, and how has practice adapted to it, and whether there is a need for new rules, standards, or guidance. Panel 1 will discuss the use of technology in arbitration. Panel 2 will discuss online mediation. And panel 3 will discuss dispute resolution on online platforms. I will be moderating panel 1 and 2. My colleague Jay will be moderating panel 3. Without further delay, I would like to start the discussion for panel 1. Panel 1 will be discussing electronic communication, case management, e-document production, new forms of presentation of submissions and evidence, online hearings, electronic awards, and AI in the decision-making. The speakers we have for panel 1 are, in first name alphabetical order, Mr. Andres Hanna, founding partner, Hanna and Gill Dispute Resolution, and UNCITRAL Working Group II chair. Mr. Joaquin Terceno, partner of Freshfields Burkhouse Steringer, Dr. John Ribeiro, Senior Legal Counsel, Impex Corporation, Professor Maud Pierce, Professor of Ghent University, Mr. Toby Landau. Also, just to mention that Professor Maud Pierce is joining us online, and Mr. Toby Landau, KC, who is also joining us online, barrister in London, advocate for Dixon Hill Chambers in Singapore, and also arbitrator. Ms. Yoshimi Ohara, partner with Nagashima Ono and Tsunematsu. And we have finally the special speaker for today, Judge Makoto Hashizume, Director for Information Technology and Civil Procedure with the Civil Affairs Bureau of the General Secretariat of the Supreme Court of Justice of Japan. So we will start with the topic of electronic communication. I would like to kindly ask my dear friend Andres to open the discussions, as you always do for Working Group II. And let me ask this question. Looking at the arbitral proceeding from the beginning to the end, what are the prevalent means of written communication in arbitration? And let me also ask the question from this angle too. Are there procedural phases in arbitration that remain paper-based? Please, Andres.
Well, thank you. Thank you very much, Takashi, and thank you very much for this invitation. It's been a long way from Chile to here, but I really appreciate being in Japan, in Tokyo. It's a country that I really like and a city that I love. So thank you again for the invitation. Well, let me start by referring to your two questions. What are the prevalent means of written communication in arbitration? And I would say that electronic means of communication are currently the most common modality in international arbitration proceeding. This was the case before the pandemic, and I think after the pandemic have become even more common ground in most arbitrations. Issues of efficiency, cost and time, but also environmental concerns, I think, have been the source behind this change. What are the electronic means of exchanging communication? Well, the most typical one is email. The email is the predominant means of exchanging communication, exhibits, and other submissions in international arbitration. If you look at the most used arbitration rules, they explicitly refer to communication by electronic means, and almost all of them mention email as one of the possibilities. That provides or allows for a record of transmission as email does. This is the case of Article 2 of the UNCITRAL Arbitration Rules, or Article 3.2 of the ICSID Rules, or Article 2.1 of SIAC. There is other means of communication that have been increasingly used in arbitration, considering the amount of data that is in cases. One is the file share transfer sites. This is cheap. Some of them are even, doesn't cost. So you see in a different type of arbitration, large and small disputes. If there's been some surveys that say at least 36% of cases now use this type of file share transfer sites. The physical data carriers have become a little bit outdated, but I myself and other arbitrators that are somehow old, we still like to have USBs or other form of hard drives. Easy to carry for us. We don't have to deal with technology, but I have to say that some security considerations increasingly make that law firms or even parties that doesn't allow anymore to use this because of, as I said, cybersecurity consent. But still, you will see there is somehow a preference by some arbitrators. And the other is the online case management platforms. I would say is the most advanced method you will see in big disputes, because this allows to find the documents, to search the documents. There are providers, external providers out there that do this. There is a cost associated, so this is why probably you will find this in disputes where the stakes are higher than smaller or medium disputes. I have to say that sometimes represent somehow a relevant cost, but at a big dispute is become not that significant and really creates a big difference in terms of or making documents organization and data search much easier, or even I would say workable. So in terms of rule and practices in arbitration, I would say currently electronic means of communication is the reality. The use of electronic copies of the parties' submission, including exhibit and other relevant documents, is not new. I would say it's common ground, and in the first procedural order, you will find in international arbitration that the electronic means are becoming the rule. Before the pandemic, I would say that often arbitrators requested some hard copies, sometimes hard copies of the entire case, even though you have to have a big room around the house to store all of them. But I would say that after the pandemic, the exclusive use of digital copy has become common, I would say commonly the default option. Moreover, various arbitral institutions have revised their rules, has become this the default option. One example is ICSID, which is here now. The default is that it will be electronically, unless the parties will ask, which I would say is completely uncommon right now. And also, if you look at ICC in the 2021, also they made some changes to be clear that hasn't to be a hard copy. What has to be presented can be perfectly well an electronic copy. So that takes me to your second question, which is, are there procedural phases in arbitration that remain paper-based, and why is that? I would say that there are two sources that why still there is paper or paper-based in arbitration. One source is practice, and the other is legal rules or applicable law. And why is that? When I speak about practice, is because less experienced parties, I would say, or centers around the world that are less familiar with electronic means or have less access to technology are still using some paper or use paper in the arbitration, even though I see even a regional trend moving towards electronic means. And still there are some arbitrators there that prefer to have some documents. Recently, a case that I'm sitting, one of arbitrator requests for a core bundle in paper, A5, because we want to see the paper. I can understand that because I'd still like myself to touch the paper at some point. That is becoming the exception, not the rule. The second, I would say, is more, well, it's relevant, which is arbitration laws. And why is that? Because some arbitrations law may preclude the use of electronic means or make uncertain the use of electronic means, which is the same for lawyers in certain procedural events. There is a report that I've done many of them, but it's interesting looking at these reports out there. What it tells that the notice with respect to the notice of the commencement of arbitration or the notice of the award, there is still some legislation, local legislation that require a hard copy. Or put in differently, it may be an issue not to provide a hard copy. That for lawyers is the same, right? You don't want to run into uncertainty. So even if it's not strictly required, the party would do to be on the safe side. And this takes me to probably one of the two last points that I want to make, which is precisely in this issue of domestic law requirements. Also, international instruments may create the need for a paper or a paper-based copy. If you look at the New York Convention, for example, New York Convention in Article 4A speaks about a duly authenticated copy of an award or a duly certified copy thereof. Doesn't say it has to be paper-based, but in certain jurisdictions, you need to come up with a paper-based of the award. And similar language you will find the UNCITRAL arbitration rules or in the model law. As I said, does not say it has to be hard copy, but it will be subject to what the practice or the applicable law in each jurisdiction require. A good news about that is that UNCITRAL is doing a good work in creating model laws for electronic signature, because at the end, that's probably where the problem will have to be solved. Or Anna mentioned us about the digital approval of digital identity management model law as well. And to finalize, I would say that the last point that I want to make is that There are certain considerations also that have led the practice to maintain some paper-based. Some people have raised concern about issues of fairness or due process in some of the hearings, for example, that the expert or the witness will have access to the entire document as opposed to just a screen with part of the document. I heard that in many occasions. That means that you have to have a core bundle or a bundle with the documents there or the expert report in front of the witness. And probably that's something that makes sense from the point of view who's been cross-examined. And the last point is, I think, is that it's also relevant to consider that it may be some material concern about confidentiality or cybersecurity that has to be mitigated. Here again, international arbitration community has developed protocols and a number of reports, but looking at them still, I think they are a bit complicated, difficult to follow, and it will be a process of learning in the arbitral community how to deal with the cybersecurity issues or issues of confidentiality related to electronic communications. Thank you very much.
Right. Thank you so much, Andres, for your comprehensive comments. And I also want to turn to Jack, knowing your extensive experience in arbitration, to follow up if you would like to add anything to Andres' point made.
Sure. Thank you, Takashima-san. And just quickly, thanks to the Ministry of Justice and ICSID and UNCITRAL for including me in the panel today. I would just add, I think Andres hit all of the major points there. I would just sort of highlight again the fact that where we do still see a lot of paper used is during the hearing procedure. And this is both, as he mentioned, the bundles for witnesses so that they have the documents in front of them and they can look through them. The expert reports, the witness statements are always provided in hard copy in my experience still, but also a bundle for the tribunal. And I think there's two reasons for that. One is that there are a lot of tribunal members that still request that. They still want the hard copy documents. Again, they kind of like the feel of the paper in their hands. But I think there's also a sense with some lawyers, at least, and I'm not sure how legitimate this really is, but we love when we're making our opening arguments and the tribunal member is actually highlighting something on the hard copy document, because you believe that then during deliberations, they will go back to that and they will remember the thing that you highlighted, that you drew to their attention during the argument. And a lot of tribunal members maybe aren't quite as adept at the technology to highlight things on the screen, even though that can simply be done these days. And I think we are moving more towards doing everything electronically. But I do think that it's kind of a general move, because a lot of people still do like having that hard copy in front of them so they can flip back and forth as people are talking about certain documents and see what else that document might say.
Right. Thank you, Jack. And I hear from you and also Andres that there are still like preferences or practical considerations that make paper still a means to be used. And the other thing that I hear from Andres is about the legal consideration of awards or enforcement phase being paper-based, which makes a segue into my next question I have for Maud. We have heard comments based on experience as practitioners from Andres and Jack. And let me turn to you, Maud, to share with us an academic perspective to this question. Are paper-based awards still the most prevalent means of making and communicating awards?
I would definitely say yes. Can you hear me, by the way? Am
Yes,
I audible?
We hear
Okay.
you very clearly, yes.
All right. Takashi, would you mind sharing the graphs? I don't know if you have them handy, otherwise I can upload them as well.
Do you have control over it, or otherwise
I can share screen apparently, so I can let me
Yes,
see.
please.
Does that do anything? Yes. Can you guys see that? Okay.
You see it very clearly.
All right, so this graph shows some of the work that we have done with the Center for the Future of Dispute Resolution. We conducted a study which was addressed to arbitration institutions, and that was aimed at mapping out the details of award rendering practices and also at exploring the reasons why practitioners would use e-awards or would not use e-awards. And indeed, what we saw there is that 30% of institutions, and that's the blue part that you see, still sends awards exclusively on paper. So that's not very surprising, I think. there was 10% that indicated that they would issue only electronic awards. One institution indicated that that was standard practice. Another one indicated that it was standard practice in domestic cases only, and for international cases, paper awards were still used. And then the majority of institutions, that's the orange part of the circle, provide both paper and an electronic version. And of these 62, 0.5%, 80% indicated that these electronic versions consist of most simply scans of the wet ink originals, which I think makes sense if you consider the paper version still the original one.
Thank you, Maud. And what do you think are the reasons that make paper-based awards more common, as you have provided us with some statistics just a moment?
Mm-hmm. Well, I think to put it bluntly, because arbitrators and arbitration institutions alike adopt a better safe than sorry policy. And I think that's also what Andres referred to when he talked about uncertainty. And what the graph shows is that everyone agrees and recognizes that there are clear advantages to having an electronic award in terms of saving costs, in terms of saving time, in terms of user friendliness, ecological footprint, and so on. But efficiency is, of course, and justifiably so, not the only concern when it comes to rendering awards. There's a big gray area that you see there at the bottom that represents 80%, and that shows that respondents put more trust in paper awards with respect to enforceability. That was already mentioned here as well, which is obviously the most important characteristic. And on many other characteristics, there is still a large or a considerable group of institutions that is more hesitant and that prefers awards on paper. I will not read out all the reasons that you find there, but I do want to point out that while it's very obvious and understandable that there is a major concern when it comes to enforceability, our suspicion is that some of these other concerns or points of view of what is better have to do, first of all, with a sort of misguided trust in people and paper. Why would the integrity of a paper award be so much better than that of an electronic award? And also perhaps a lack of knowledge about the potential of certain technologies, like with registered emails, for instance, which are at least as good as courier services when it comes to certainty of receipt. But again, to come back to your question, the core of the problem is enforceability, or at least the perception of enforceability issues in light of the common core of award formalities, which prescribe, as was already mentioned, that an arbitral award must be in writing and must be signed by the arbitral tribunal. And that seems to be the biggest issue here.
Great, thank you, Maud. And thinking ahead and in relation to your point about enforceability, what would you think that would increase the acceptability of EU awards? And do legal frameworks need to be adjusted to overcome issues such as enforceability with regard to the in writing or the wet ink signature requirements?
Well, I think your question is very on point, and the way you phrase it as well, because I think the first question we need to ask is whether there is a legal rule that actually prevents the use of e-awards. And I'll start there with the writing requirement. The writing requirement can indeed be found, as was already mentioned, in many institutional rules and arbitration laws. And according to many people, there's also an implicit writing requirement in the New York Convention. But one could wonder whether that should be a legal obstacle to e-awards. In our view, the writing requirement is not a tangibility requirement. The writing requirement is usually not much more than a way of excluding oral arbitral decision making. So it's a means to an end. It's not an end in itself. It's a way of making sure that compliance with certain more substantive requirements can be verified. You know, the date of the award shows or makes sure that the award was rendered on time, for instance. And it ensures due reflection. So the writing requirement, in our view, has very little to do with the distinction between a written text in digital format and written text in intangible format. So it's not a requirement that precludes an e-award. And this is a view that was shared by the overall majority also of the surveyed institutions. The same could be said about the requirement that an award must be signed. If you have a proper e-signature, then you could, from an arbitration law perspective, consider the awards signed. But the key word here is proper. So it must be a proper e-signature, and this may be an issue. It was already also mentioned by Andres, because in an international context, whether or not there is an e-signature will depend upon applicable e-signature laws. And if we have to pinpoint where exactly in the legal framework there might be a problem or the perception of a problem and where we could, come up with a solution, this is probably where we have to look. Because the most important legal complication may be the fact that different jurisdictions have different e-signature laws and standards in place. So what may be a qualified electronic signature in one jurisdiction may not have the same status in another jurisdiction. So the actual issue might not be one of permissibility of a digital signature in itself, but rather its international enforceability. Foreign signatures that do not comply with an enforcement form's requirements may not benefit from the same special evidentiary status as the domestic preferred e-signatures, and that would perhaps not be an insurmountable complication, but it could lead to a bit of a hassle. So looking at these two examples, the issue is more one of perception and risk assessment, and this was also confirmed by a majority of 61% of the institutions that indicated that they believe that using only electronic awards without any paper originals is too risky under the current legal framework. So we also asked them what could be done to overcome that risk, and the answer that we got from the large majority was that in order for electronic awards to be legal in a given case, an express rule allowing electronic awards would be necessary.
Thank you, Maud, and also highlighting what parts of the provisions or the standards that exist are relevant to look at. And also, I think with your observations, we have much to be looked into in terms of e-awards. But we would probably like to ask more from you, but because we do have time constraints, and I'd just like to proceed to the next question. And so with apologies for taking participants back and forth, we have just looked at the very end of the arbitral proceeding, and now we go to what some of the things that goes on in between. And the next topic that I would like to discuss is case management. This is a topic that is actually quite dear to my heart. It reminds me of the enthusiasm that I had in settling disputes as a judge. And discussing case management, I have Toby, and let me ask this question. What is the magnitude of the flood of information problem, given the increase in the volume of information exchanged in arbitration?
Thank you very much. Great pleasure to address this forum. I hope you can hear me clearly. It is often thought that with the increase in technology and digitalization, there has been a flood of information, which is difficult to cope with, especially in arbitration. Actually, the position is a problem independent of technology. And what's happened is technology has made it even worse. So I think to understand the case management challenge that's faced in international arbitration nowadays, one needs to start pre-digitalization. What actually is the problem, or aside from digitalization? There is a fundamental imbalance between the activity of counsel and the ability of tribunals to deal with information in arbitration. I'm generalizing across all sorts of different types of arbitration, but this, I think, is more commonly the position. The standardized model that we are using in international arbitration is the Anglo-US adversarial model. And that is one which entails a rather passive tribunal that waits to be educated and informed by the parties. And the way that that information process proceeds is by way of an extensive written phase, followed by an extensive oral phase, followed by an extensive post-hearing written phase. And through the course of that, there is an accumulation, in many cases, of an absolute mass of information, which is then dumped upon the tribunal for it somehow to deal with, to go through and to isolate the issues and make its determinations. In terms of the written process, if one breaks down the sequence, the standard practice now is all-encompassing written memorials, normally 4 of them, 2 exchanges. They are produced by very large teams, normally, of law firms with any number of unnamed associates working in windowless rooms who haven't seen their families for long periods of time. They generate hundreds of pages of submissions with very little selectivity in what they're actually putting forward, because the overall approach is to be safe and therefore include everything just in case. On top of that, we have very cumbersome witness statements now. Witness statements have become an advocacy tool. They are drafted by lawyers and they resemble submissions. They're lengthy and they're detailed, and they add to the burden of arbitrators. On top of that, we have lengthy expert reports, and then we have document disclosure. Document disclosure generates a vast amount of material. Only normally a limited amount will actually be determinative or relevant to the dispute in the end. Then you move into the actual hearing, which will generate a lengthy transcript with opening submissions and examination of evidence and witnesses. And then you have the post-hearing phase with further written submissions. If you step back and look at the impact of this on tribunals, very often it's actually a very, very difficult situation to deal with, because tribunals don't have the vast legal teams that parties have had, which have been needed to generate all of this material. So this ends up as boxes in the corner of the tribunal's room, or as a huge amount of data on their hard drives, which they have to somehow filter through. And if anything, the problem is that this degrades the arbitral process, because if arbitrators are struggling to manage all this information, that will actually undermine their ability to make determinations and come to a proper result, which isn't superficial or selective or prone to cognitive biases such as shortcuts, confirmation bias, many other things, which will impact the decision-making process. So that's a standing problem. When you now put that into a digital world, all those problems get compounded, because the ability, what technology has allowed us to do is to actually generate longer documents. We write now on screen rather than paper and pen. And so our memorials are much longer than they ever used to be. And of course, when you're typing, you type and put everything on screen, thinking that you will edit later, except we don't. We tend to leave it there because it has an existence once it's on the screen. And therefore the submissions tend to be much, much more bulky. On top of that, the technology has allowed us to do much more in terms of document disclosure. And of course, the very existence of electronic documents means that many tribunals nowadays are faced with thousands of emails to sift through, and now more commonly, thousands of WhatsApp messages, which we increasingly see as the product of a disclosure exercise. I think all of that put together means that we are faced now with a challenge. It's not so much that technology is helping us. It is helping in some respects, but it's also enhancing some of the problems. And that leads into a challenge as to how we address it.
Thanks so much, Toby, and for highlighting the problem of flood of information. And as a follow-up, I would like to ask, what are the procedural tools actually available in arbitration to address this problem? And also, how could they actually be updated if we were indeed to take this seriously and solve this issue?
So I think, first of all, we have to take it seriously, because with the growth of arbitration over the years, we have had alongside a consistent series of complaints, which are articulated at arbitration conferences on a regular basis, and generally by users, that the process has become too long, too expensive, too cumbersome, and actually not always an attractive alternative to court litigation. So we have to address it, because the costs and the delay are in large measure due to these case management problems, or the problem of too much information and redundancy in the process. There are many available procedural tools now that can be used. We do not need to change rules. We don't need to change laws. We just need to change attitude. And by that, I mean that the problem, as I see it, is largely an autopilot problem whereby tribunals sit back and apply a standardized procedural model to every case without actually rolling their sleeves and doing active, affirmative case management. So what tends to happen is when the case starts, you will get issued a standard form procedural order number 1, which in fact is not doing what arbitration should do, which is to produce a tailored process to the particular needs of the particular dispute. If it's a standardized PO1, that means you are going to have redundancy, because you may not need all of this process for every case. And so this really looks towards challenging this Anglo-US model, this adversarial model. And to my mind, the solution is to put the burden on tribunals to actually act more inquisitorially. Doesn't mean that they have to shift to a civil law process as opposed to a common law process, but it does mean that tribunals need to actually have a full understanding of the case from the beginning. They mustn't act passively and coast along, which many tribunals do, until the moment where they actually have to take decisions. And they need to use all the flexibility that's available to them to actually focus on what the issues are in each case and what procedure is needed for each of those issues. And that can be in concrete terms, actually limiting the scope of written submissions. It can be limiting the scope of witness statements, of expert reports. It can be limiting the scope of hearings in order to actually focus on what is needed. And this is where I think one can say the technology is actually now available to us in a way that has never been there before. And I'd just like to add this point, which I think is perhaps the most important. When the pandemic happened, we started by trying to simply replicate what we did in person on remote formats by Zoom or other platforms. And actually what we've learned is that that is a mistake. What we mustn't do is replicate what we used to do because we had to do it that way, because now we can do it differently. And one of the key points is case management. In the old days, it was difficult to case manage actively throughout an arbitration, because to call a case management meeting often meant requiring people to travel and requiring a coordination of diaries. And therefore, there was a disincentive to doing it. I have memories of getting on planes for half-day procedural hearings, which nowadays is completely unacceptable, apart from anything else in terms of the environmental impact. Now we don't need to do that. We have Zoom. We have the other platforms. Actually, there's no excuse. Tribunals can meet with the parties as often as they want, with the counsel as often as they want. Coordinating diaries is no longer a problem. There can be short hearings. They can happen frequently. And the other thing I'd say is that with the technology, we now have greater accessibility to the process. So parties who may be far-flung can log in and actually appear, whereas they might not have appeared previously. And so the tools are there and available for tribunals to be more proactive. And that, I think, is one of the benefits of the change that we've all experienced since the pandemic.
Thank you so much, Toby, for making those points. And I also now like to turn to Andres for a brief follow-up on perhaps what Toby has just mentioned.
Thank you very much, Takashi. It's been a pleasure to listen to Toby. I will not repeat what he said, but I will make a few comments. The first one is that I do agree with him that you need somehow to think about how to change the business model if you want to have more active tribunals, more involved, and also the parties more involved during the process. Not wait for the exchange of written pleadings, then the production of documents, prepare for the hearing. And I have to say, even though it's very close to my heart, is that expedited arbitration in particular. That's the model in which it's based. It's a model where you only have 6 months to decide the case. If you have 6 months to decide the case, you need to have a case management conference very right away and monitoring the process, because otherwise you will not be able to decide the case. So it needs more involvement by the arbitrator, more involvement by the parties. Having said that, I would like to also say that first, this is not the Anglo-Saxon model. In many parts of the world, from the region that I'm coming from, is exactly the same models. You know, courts are also passive. So maybe countries where courts are more active, that's not the case of the region that I'm coming from at all. So it's also a cultural issue there. Second or third, that we also have to remember that I want to make a word of caution in this, because case management works and the more active role of the tribunal works as long as actually the tribunal is really getting the information to be able to act. And we have to remember that tribunals know little about the case during the first time of the case. Probably tribunals start understanding the case with the written pleadings, and then when they read the written pleadings and they come to the phase of the document production. So I have the experience in certain cases that a very active tribunal may create as well confusion on the parties and may lead the parties to the wrong or lead the parties in a wrong way. So that reminds me that as an arbitrator, we have to be humble and remember that the parties are the one that know the case better than us and work together with them, but also be careful about that. Too much intervention could also lead the parties in the wrong direction. So totally agreeing with Toby in that we have to think about the model and how to deal with this massive amount of information and how technology can help us. I would say something that I always repeat, that at the end, what we do, and we have been doing as arbitrators at tribunals, it works. It needs improvement, but it works. The core of what we do in solving disputes, it works. So if we will change the business model, we will require a significant cultural change by the tribunal and by the parties, and also understand how this cultural change has an impact on what we do in terms of solving the dispute properly. Thank you.
Great, thank you, Andres. And let me just briefly pause our discussion for a moment. As I mentioned at the beginning, we now have Judge Hashizume, or Makoto as we go by our first names. He's joining us online. Could I kindly ask you to give us your presentation on the use of technological means in managing Japanese civil court proceedings? Please, you have the floor.
Thank you, moderator. I'd like to explain 3 points about the recent efforts for digitalization in the courts of Japan. Okay. Yes. First, we began operating a new system for allowing some litigation documents to be submitted in electronic form in some pilot courts this April. Each party can submit a document via the internet and receive the document which is submitted by other party at any time. This is an attempt to implement e-filing in advance before the amended act is enforced and full-fledged digitalization is realized. Since all attorneys will be required to submit a document online in 2026, we believe we should operate this system as soon as possible for both attorneys and courts to become familiar with the way to file online and prepare for future electronic records. Secondly, regarding the e-courts, our web conferencing system, which is Microsoft software Teams, is widely used in the proceedings to arrange issues and evidence in the courts of Japan. We started web conferencing system in 2020 in some courts, and now this system is available at all district courts, including branch offices. The number of proceedings using web conferencing system has increased dramatically, mainly because of the situation caused by COVID-19 pandemic. In addition to the web conferencing, we also use other functions of the system, such as chat function, sharing document, and editing it with both attorneys. By using these functions to communicate with attorneys, it becomes easier for judges to clarify and focus the points and issues of the case. Thirdly, the business court was established as the first court complex in Japan, which intensively handles business-related cases this October. This business court aims to serve as a new type of court that can meet users' expectation by using digitalization. For example, since we anticipate that web conference will be conducted on a daily basis in the business court, special facilities which is appropriate for a web conference are shown as a picture has been set up. In conclusion, digitalization of civil litigation proceedings not only contributes to improve access to justice, but also is a good opportunity to change the court proceedings better and to make the resolution of disputes more speedy and more convincing to the parties. As we will make more use of technology in the near future, we will aim to further enhance trust in the judiciary. Thank you very much.
Thank you so much, Makoto. And I understand you have back-to-back commitments and you have to leave. It's a pity that we have to let you go, but thanks again. And as we continue our stock-taking exercises, UNCITRAL will continue to look into also court practices as well. And going back to our discussion about case management and arbitration, Toby, I will come back to you again, once again, and I would like you to share with us your thoughts about, or you have already touched upon this question, but how can case management be done better? And are there any digital solutions to this problem that you may wish to add at this point in time? Thanks.
Thank you very much. I think I've probably already addressed this, but I'm going to be cheeky and use this slot just to quickly respond to Andreas, if I may, and his observations on my observations. I think he's absolutely right to say that one's got to look at this in a measured way. So I'm not advocating that the process is terrorized by arbitrators and that parties no longer are allowed to make their case because the tribunal is overly interventionist. Certainly not. But one does have to change the status quo because we have now had several decades of complaints about the arbitration process. And I think what is very important for all of us to bear in mind is that we in arbitration are now competing with a new brand of commercial court, international commercial courts. And those commercial courts are now actually using digital and technology processes and active case management by judges that produce a process that's much more efficient in many ways than some arbitration. So I don't think we can now say, well, our process works and therefore we don't really need to do too much to it. Because actually, for some of us who practice in commercial courts as well, arbitration looks second best in many cases. These are courts such as, for example, the Singapore International Commercial Court, the London Commercial Court, many other commercial courts around the world, the DIFC, and they are using technology actively to do what I'm suggesting, which is judges adding a discipline to the process by being able to monitor it as it goes along. Doesn't mean that parties don't run their own cases, they do. But it does mean that the judges have to be, and I think the arbitrators also, actively engaged. And that level of engagement is something which we now can do with technology. Whereas in the old days, we simply waited for 1 or 2 hearings and to receive submissions without actually meeting the parties.
Thank you, Toby. And yes, when I was planning on these discussions, I had no intention to bring in competitors to this panel, but still, competition brings opportunities to make things better. And I now turn to Andres to perhaps address or respond to Toby or any additions to be made. Thanks.
It's a pleasure to respond to Toby very briefly. I think he mentioned what I was thinking. My concern, of course, is that in order to call for a more active role of the arbitrator, so you have obviously think about how you change the current structure of the proceedings so that would be possible. Just to give an example again, in the case of expedited arbitration, in the case of expedited arbitration, the notice of arbitration is the statement of claim. So the arbitrator will have the statement of claim when he will have or she will have the case management conference that obviously will have much more information, and obviously technology can help you to do that. So for me, how could case management be done better? I agree with him. Technology will help. I agree with him that a more active role of arbitrators would be advisable, but obviously in order to do that, we have to think how we tailor the proceeding as we know it now, in order that, or we restructure the proceeding and how we structure the proceeding, so the arbitrator will be in a position to make proper decisions in being more actively involved. I think one thing comes obviously with the other, and actually I'm repeating myself, but when you look at the more concentrated proceedings, even emergency arbitration or expedited arbitration or fast track proceedings, you see that the arbitrators have a much more active role, but also they are getting much more information at an early stage of the proceeding that allow them to do so.
Right. Thank you so much, Andres. And now I'd like to proceed to the topic of e-document production. We have heard about the increase in the volume of information exchange in arbitration. And Jack, could you tell us about what the impact is of digitalization on document production?
Sure. Thanks. And I do want to say that I just appreciate how the exchange that we just heard between Toby and Andres was basically structured just like the 2 rounds of submissions in a typical arbitration. And I agree with Toby's point about putting the burden on tribunals to deal with some of these issues, though I do think, just as a side note, that this due process paranoia that we see among arbitrators, that they're very worried about due process challenges, and so they kind of let parties do everything they want so that they can't have those kind of complaints, does seem to govern some of their decisions. I disagree with Toby on one point. Our associates do have windows. But I also agree that digitalization has augmented an existing problem to a large degree. But in terms of document production, I think the issue is twofold. And the first aspect is that it has also created a new problem, in that software has created huge volumes of documents, or what we commonly call electronically stored information, or ESI, that simply didn't used to be available, going back decades. I've done cases now where we're pulling up emails from 1994 and 1995 as part of document collection for the clients. And you didn't used to be able to do that until you had this kind of digitalization in this software. And so I think luckily for us, the second aspect of this is that the software is also assisting us in review of those documents. And so while we're now seeing a lot more documents and there's a lot more information out there, and as Toby also mentioned, we're seeing now on things like WhatsApp and WeChat texting. And to me, it's still a little shocking how much business is done on those kind of platforms, particularly here in Asia. But so now that the software has created this huge volume, we are seeing in digitalization and document production software being used to assist us in that. So while we've got more evidence available, we have better tools now for sifting through that evidence. We've got platforms, which I can talk a little bit more about, but we've got platforms that allow us to collect the documents, to sort through them, to get through them quickly, to cut through, you might have 100,000 documents, and we can use software to reduce that to a much more reasonable number that the lawyers would actually then be looking at, to deduplicate documents so that when you're collecting documents from multiple people, their emails, you don't have to look at everyone's version of the exact same email chain. You can get rid of some of that so that you're only reviewing complete chains. And of course, we've got software assisted production now. So we've got, once the documents are identified, it becomes easier with digitalization, provided that we're not in an environment where hard copies are required, where you can actually produce those documents to the other side. Andres had mentioned FTP sites, for example. There are also some various vendor platforms that allow you to do production of the documents to the other side and to the tribunal a lot more easily.
Right, thank you, Jack. And I understand that you're not a software expert, but it would be great to hear more, or if you could elaborate about how those software work in practice. So.
Yeah, I will do what I can from the prospect more of a user, certainly. And I have been using these for several years now. And I don't know, Takeshi, if you're able to put up some of the slides, sure, where it's just some visuals to show some of these things. But again, there are a lot of vendors who are putting out tools now that most of us will be very common to most of us. We've been using them for a few years, I think. One of them is Relativity. Relativity puts out their e-discovery platform, and it's got a lot of functions. It's often being improved. A lot of law firms like ours actually now have Relativity in-house, where we've got our own version of Relativity that we can use for cases, so we don't have to go out and hire the third-party vendor, especially for the smaller cases. And this is a platform that's got some very advanced search functions. You can review workflows on the platform. And so this on the screen is just an example of what a Relativity screen might look like. But it offers all the steps you need for a really structured review of electronic documents. So it lets you uniformly extract searchable text. You can extract metadata from the documents. You can identify patterns in the information to group documents together. It allows you to tag documents with various themes, various issues that you might be looking for. Importantly, you can tag documents as privileged, so you can avoid inadvertently producing things like that. You can create these priority review queues on Relativity so that you can identify certain documents that seem to be what we commonly call hot docs or key documents, where you can review those first. You can use issue coding to redact documents. So you can actually do redaction in batches of documents, which makes the redaction process a lot easier when you have to produce documents where you've got either some privileged information included in that document or some commercially sensitive information or irrelevant information that you're redacting. And the platform also allows you to prepare the documents for production. So in addition to using a platform like this to do your review, to do your search, you can use it to then take the outcome of your search and the data set of documents that you need to produce to the other side and use the platform to actually make that production. And one thing that's important, I think, about these kind of platforms, in addition to making it easier to actually do the review, it allows you to do, as we know in arbitration, there's much less document production. Yes, there has been more over the years, it's been growing, but I come from a background of US federal litigation where, I've had cases where there were millions of documents that we had to go through, and there were literally hundreds of thousands of pages produced to the other side. So a platform like this becomes really priceless to do that kind of work. It used to be that we'd hire a team of temporary lawyers that you would actually bring in, and you'd have 12 people in a room. That room may have been windowless, actually, and they would go through, they'd spend 6 months doing nothing but document review. That was their only job. And these kind of platforms mean you're not doing that so much anymore. On the screen now is the Opus 2 platform. This is just another example It's often very much used for hearings, which I can maybe talk about in a few minutes, but you can use this for document production as well. And you can bundle a platform with Opus 2. So the nice thing about Opus 2 is it sort of replaces FTP sites in that you can have a section of Opus 2 where you're uploading documents that both parties have access to, and that you can then have another site where both parties and the tribunal has access to. But on the same platform, your team is allowed to have your own area of that platform where the other party in the tribunal does not have access, where you can do your work. You can review documents, you can make comments on documents, you can make a comment that's directed to another team member, so they get an alert saying that there's a comment there for them to address. So that's become very helpful, another very helpful tool. The last thing I want to talk about is just predictive coding. So this is, in the US, this has become very familiar. And what predictive coding does is it leverages machine learning so that you can do the search of documents and you can identify relevant documents, again, in a very easy or much easier way. It takes a little training. The lawyers will spend a little time to train the system what they're looking for, and you do a couple of test runs so that you can look at the documents that it's giving to you as relevant to make sure that they're actually relevant. But it's a very, very helpful tool. And since 2012 in the US, a case called De Silva Moore v. Publicis Group found that predictive coding was actually reliable, could be used, and indeed should be used. A lot of the US federal courts now are requiring the parties to use predictive coding for the document production phase in a lot of cases. The UK has taken a similar approach, a case called Piro Investments in 2015 2016 also said that predictive coding was an acceptable means of doing this. And just to close out the answer to this question, I just wanted to read one quote from an Irish High Court case in 2015 dealing with predictive coding and this kind of use of technology for document production. And the judge in that decision said, quote, "The evidence establishes that in discovery of large data sets, technology-assisted review using predictive coding is at least as accurate as, and probably more accurate than, the manual or linear method in identifying relevant documents." That case was Irish Bank Resolution Corporation v. Quinn. And the idea behind that is actually the software has gotten good enough that it's more reliable than having that team of lawyers sitting in the windowless room 10 hours a day going through documents trying to decide what is and is not relevant.
Thank you, Judge. Jack, not Judge. Yeah, picking up on your last point about the Irish court decision and mentioning that it might be more credible to have a software deal with document production, or maybe, as the process is called, maybe discovery. In Ireland, I have no idea, but there seems to be some lingering concerns about these softwares may not be as credible as human reviews, and in those to respond to those kind of issues, what do you see as being the legal safeguards that needs to be applied in utilizing those means?
Sure, I think one of the most obvious and straightforward legal safeguards is that before anything is produced, it's still, some lawyer has still looked at it. So we'll use these tools to narrow down the set of documents that we're going to produce, but we will still then review that set, what's left, before we actually hand it over to the other party. And in particular, you need that, for example, to not inadvertently produce privileged documents, and also just to make sure that the stuff is relevant. One thing I should say about these tools is that whereas, again, in arbitration, we're producing fewer documents, maybe more than some of us would like, but fewer than you do, particularly in something like US litigation, you still are needing to look at huge data sets. So you, as the lawyer, have to go through all the documents that your client has to put your case together and to find all the evidence that you have. So you still, whether you're going to produce them or not, you still need to look at everything in some way. As far as other legal safeguards, one thing you have to be aware of course, particularly these days, are data privacy laws like the GDPR. When you're transferring these documents for document production from one jurisdiction to another, you have to make sure that you're aware of what kind of data privacy laws might apply, how you can address those laws. You have to understand those applicable laws and put in place whatever safeguards those laws might require. Sometimes a confidentiality agreement might be enough. Often using them in arbitration actually provides exemptions. So just as an example, GDPR articles 44 to 49 talk about the fact that if the transfer is occasional and if it's, quote, necessary for the establishment, exercise, or defense of legal claims, in that case, you can make some of the transfers. So it's just a matter for your legal safeguards of being aware of what laws apply. And then I think you also have to be aware of the risks that might be created by moving documents into a certain jurisdiction. So there's a US case, Ratliff v. Davis Polk from 2003, where the third party was trying to get documents for a foreign company that was a client of Davis Polk, the US law firm. That foreign company wasn't present in the US. The documents, it didn't have the documents in the US, but Davis Polk had the documents in its New York office. And so the court ruled that as long as they weren't privileged, they were subject to production because they existed in the jurisdiction. And so you find firms, I think, taking creative approaches to that. We actually did a case once when I was at my former firm in the US, where we had documents in a database in Europe that we needed to review. And we set up a system in New York where we could see them on monitors, but we could not print them, we could not download them, creating the legal, maybe a legal fiction, but at least a legal argument that those documents had not actually come into the jurisdiction, that they weren't actually available for discovery in New York because they hadn't entered in a way that we could actually produce them and discover them. That hasn't been tested to my knowledge, but that is the kind of safeguard that people are starting to take, using technology to do sort of remote reviews so that the documents stay on a server somewhere else.
Right. Thank you, Jack. And I've been keeping John on hold for quite a while, and I just wanted to ask you to share your perspectives about this issue.
Yeah, no, thank you. And thanks for the opportunity to address this distinguished forum. I'll just add some perspective from kind of an in-house or a user. So yeah, it's all about, as an in-house team, trying to reduce the volume and reduce the lawyer hours that are spent on our documents. So everything that, Jack, you said, it just kind of makes me shudder a little bit about lawyers tagging various things and, you know, discussions probably at 11 p.m. Is this a relevant document? Is that a relevant document? I mean, that's just it can be very, very expensive. So our job as an in-house team, and I think more and more Japanese companies are starting to find out how to turn 10 terabytes of documents into maybe 1 terabyte of document that can then go on to the lawyers for review. Another important is stakeholder management for an in-house team, and it's really internal reporting and being able to be on top of what the external team are doing with document production and e-document production and tagging documents. So the more ability that an in-house team has for real-time involvement with that process, whether it's being able to log in and monitor what documents are being tagged as relevant or hot or, you know, highly sensitive, the better. The ability to escalate those documents internally and, you know, line up potential witnesses to provide an answer so that we can be there when the legal team needs that information is important. And just, you know, being able to report to management in basic real time, because that's when the questions come is what's going on, how many documents have been reviewed, how long have they been spending, how much is on the clock. All of those questions come with, you know, 10 minutes notice, and we need to be able to provide that information to our internal stakeholders. Japanese language documents are, you know, I think the technology's come some ways. I'm not sure if it's there yet in these platforms to really handle and do predictive coding on Japanese language documents. Oftentimes I hear that there will be a translation of the Japanese into English, and then English will be dealt with in an English manner. But I think there is some improvement there, but that is a concern. And then what happens with those Japanese language documents? Who's the review team? Are they within the law firm? And if they're not, is that external review team trustworthy? Those are concerns for a Japanese company. You mentioned GDPR and data protection. That's another question as an in-house team that we get a lot. Or is this information safe to provide? How can we make sure that, as you said, it's not going to be exposed to some foreign jurisdiction discovery order? I think the example that you gave, make sure that the information's on a secure server within Japan, access online to that, no ability to download. And those are solutions that I've come across in practice. AI, as you said, is brilliant development. So it's kind of, I don't know if we can call it AI, but it's that learning as a reviewer goes through a document, that the system learns on what type of documents the reviewer considers to be relevant and pushes those to the front of the queue. So at the end, you just get documents that are irrelevant. That's all useful tools. Yeah. So what can an in-house lawyer do early? Well, it's making sure, and this is, I think, perhaps not common practice yet in Japanese corporations, but is getting out document hold notices early, pre-dispute phase. Make sure people are locking down those potentially useful documents and are able to comply with document production orders when they come. And educating the business teams. Someone mentioned WhatsApp messages. They are a nightmare for internal teams. We can't control what our business teams are doing on WhatsApp, and then we can't review those messages to provide early pre-dispute advice. So those are issues that we're going to have to deal with, and hopefully with the help of external counsel. That's all I think I had to say on that.
Right. Thanks, John, for your perspectives from users' standpoint. And now let's move on to the topic of presentation of submissions and evidence, and an area that we're seeing developments and actual use cases. So, and I turn to Jack again, and I just understand you have practical experience to share with us. So could you tell us what the latest technological means are used for the presentation of submissions and evidence, such as in construction cases, perhaps?
Sure. And if you are able to put the slides back up, we were on the slide of the Opus 2 platform. And in addition to document production, Opus 2 actually provides, it's an example of one of the very good platforms for presenting evidence during the hearing. You can create an electronic documentary record on that platform. And as I had mentioned, the attorneys can then use it to annotate documents, to make notes, to send comments to other members of the team. You can create virtual binders for your cross-examinations there so that the other parties and the tribunal have access to those. That can all be created on the platform to then be used during the hearing. Again, trying to, as much as we can, move away from hard copies and paper. So those binders can all be created on the Opus 2 platform and then easily accessed during the hearing. And you can also access the platform from really anywhere in the world from a variety of devices. You can access it on your laptop, on tablets, and on other devices. So the way, that a lot of us, of course, are working remotely far more often now, this is a platform that allows you to have that access without having to be in the office or without having to be on one particular device. And one thing that I also like about this platform and this type of platform is you can create hyperlinks within the documents. So now you can have your memorial so that when you reference an exhibit, you reference, say, Exhibit R15, that is a hyperlink. And the tribunal member can just press on that link and Exhibit R15 will pop up because it's also there in the same database and it's been linked to your memorial. So it makes it much easier for people reading through the memorial who want to review that evidence that we're talking about to actually immediately pull that evidence up and take a look at it. Using it at the hearing on the next slide, this is probably a visual that's very familiar to people, which is just the kind of things we have at hearings now. We have screens. I mean, I've got 3 in front of me now. We all have screens in front of us here just for this panel. At hearings, there's screens in front of everyone. There are large monitors now these days all around the room so that people can view evidence that way. So whereas it used to be everyone had a binder in front of them with hard copies and you tell them, please turn to tab 17, now you have what's called an EPE officer, an electronic presentation of evidence officer, which vendors like Opus or others like FTI will provide this team who actually comes to the hearing. They sit in the background, and when you reference a document, they're able to immediately pull it up. One of the nice things about that, other than making sure that everyone's looking at the same document, is that when a document is referenced that maybe you weren't anticipating, it can still immediately be brought up, and it doesn't have to slow down the process that much. It used to be, I'm sure most people have had this experience where you're cross-examining a witness, you've got the set of documents you want to take them to, but then they reference some other document. And a lot of times when it was hard copies, everybody would be scrambling through the volumes of binders sitting on the floor next to the witness, trying to find that document. It slows everything down. Sometimes tribunals would actually use that as an opportunity to take a break, and that would slow things down more. So now with these kind of platforms allow you to immediately pull up those documents once they're referenced. One other thing I wanted to talk about just was 3D modeling. The next two slides have an example of that. And this, you can provide both electronic and even physical creations of models. So 3D modeling can allow you then to use 3D printing to print out a model that people can look at. And this can remove the need for travel so that it can replace a site visit, depending on exactly what the circumstances are, what your facts are that you need to show. The parties and the tribunal have to kind of make a decision of whether it's good enough to replace the site visit. But it can also do things that a site visit can't accomplish. So for instance, you can use 3D modeling to, if you've got for example, a case about whether hazardous materials were contained underground or how they leaked underground. 3D modeling through animation, you can actually show what was going on underground in a way that, of course, you can't do in the site visit. You can look at the foundations, you can show the structures that were underground, you can show where you think the failure points are. Obviously, you have to have all this supported by evidence in the record, but it can be very useful for that. And this last slide is just our friends at Z-Axis, which is one of the vendors that provide this kind of service, provided this to us. This wasn't for a case of ours. This is an example they were kind enough to share. It's an interactive 3D animated model. This with the previous slide it's an oil platform and an underwater brace. And it allowed you to have a detailed close-up view of a cracked area in that brace that failed and be able to show through the 3D modeling really to try and prove your case and prove the facts of the timeline and show the development of the crack over time through the 3D modeling. So I think these kind of technologies can also be incredibly useful in allowing you to present evidence actually in the hearing room during the hearing.
All right, thanks, Jack. And I understand that leveraging these kinds of means comes at a cost, and I was curious to ask what you think are the considerations needed in applying these means.
Yeah, I think cost is one. Accessibility is another. There may be issues of how you put together the 3D modeling. So whether you have to have experts that are working together from both sides so that you're presenting a 3D model that is sort of an agreed 3D model, or you might have competing 3D models, which obviously can complicate issues for the tribunal. The other issues are the comfort level of the tribunal and the witnesses with this kind of technology, and whether they can sort of incorporate it into their thinking, into the hearing. I think one concern is two concerns that are related. One is that ensuring that these types of demonstratives, like a 3D model, are faithfully reflect the evidence in the record, because you could see that using a 3D model could be an opportunity to sort of show something that maybe is, it's questionable of whether the evidence really supports what you're showing in your 3D model. And so again, that can create problems, and it can also mislead the tribunal. And if you're using 3D models to show what might have happened, then you've got to make it very clear to the tribunal that you're not saying that this is a factual case, that, the tribunal has to understand that this is a possibility that you're presenting through 3D modeling. And so that, again, they don't get misled because of having that type of very visceral visual in front of them to think that, oh, well, this must be what happened because I'm looking at it and seeing it happen. So I think those are some of the concerns about it.
Right. Thanks so much, Jack. And I turn to John now to have some users' perspective on this issue as well.
Yes, thanks. So electronic bundles are fantastic from a client perspective, considering the cost savings. I remember as a junior lawyer looking through 40 bundles to make sure that every page was stamped correctly. I mean, that's just such wasteful time and cost. And not having to do that anymore, and not having to pay for that is a huge advantage of that technology. Another useful advancement in technology is the real-time electronic transcripts, which it's not technology that's putting it out, but it's someone typing. But for a witness, especially a non-native speaking witness, to be able to see the question that's being put to them in words, rather than trying to decipher an accent from, a jurisdiction that they may not be familiar. It levels the playing field in some ways. So that's an important development. Finally, Opus 2 Magnum, I mean, that is a fantastic system, and it's useful for the in-house team as well, to feel as though they've an opportunity to engage with that evidence, and if raise questions internally about documents that they're seeing are being relied on heavily by one side, separate from the advocacy team, but also, and maybe not a lot of influence, the opportunity to influence the advocacy somewhat through messaging over those systems, through flagging, highlighting documents as they're being put up on screen, because these systems allow for internal messaging, external messaging, as you said. So that's very important. Opus 2 and these technologies also help, an internal team and the business team kind of feel the room a bit more, so they can make an assessment on how they should be going with their potential settlement discussions. So I think they're welcome additions to the toolbox.
Right. Thanks so much, John. And while we're on this topic, I wish now to turn to Toby to ask what the impact of electronic media is on written and oral advocacy. Please, Toby.
Thank you. Thank you. This goes back to a theme that I introduced earlier, which is that we need to look at the way we do things. We have traditionally done them and reassess them in the light of the technology that's now available to us. And I think in terms of the practical exercise of advocacy, there are big changes to how we do it now as a function of what's available. If we think very briefly, first of all, of written advocacy, there are advantages and disadvantages of technology, which have an impact on style. The disadvantage would be what I've already spoken about previously, which is that the technology allows us to actually create longer documents, less focused documents. And that is a problem, both in terms of just the style and also the substance, and in particular, legal research. Legal research has been absolutely revolutionized by technology. In the old days, in the last century, when I was a student, we used to go to a library and we would look around at things on shelves called books, and that would restrict how much you would actually be able to find. Now, research is done electronically with databases, any number of them, and depending on how you search, you can gather together a mass of legal material in terms of authority across multiple jurisdictions. That can be helpful if it's filtered and if it's actually worked upon, and it can be positively unhelpful if it's just pushed into overly long footnotes in written submissions, which one often sees. So technology changes the way that we're actually writing in terms of advocacy. But on the benefits, one can also do, as you've already heard, hyperlinking. Hyperlinking has changed written advocacy massively, because one can actually have shorter documents which are readily, make the whole record readily accessible to the reader. And the use of graphics. Graphics is now a major advocacy tool. There are sophisticated law firms around the world that have their own dedicated graphics departments for 3D modeling and for other advocacy demonstratives. There's a lot of poison that you can sow in a graphic by using color and shapes and various other things of that sort, all very important in the way that we actually present our cases. Very briefly, in terms of oral advocacy, there is a major impact now with the benefit of electronic bundles. So in the old days, when you were making submissions to a tribunal, you had to actively decide how many documents you were going to show them, because there are physical limitations in asking a tribunal to move from one binder to another binder. If you're speaking to them for an hour and a half or 2 hours or 3 hours, you can't keep saying, go to this bundle, go to this bundle, go to this bundle. With an electronic bundle, if the tribunal is comfortable using it, then you can now show them any number of documents with a click of a button. You can bookmark electronically, and that means very quickly you can move from one document to another. And that, I think, now changes the focus of our oral advocacy. And I think what it will do is actually make advocates use the record more actively in the course of their submissions, rather than choosing selections and possibly putting them on a PowerPoint or asking the tribunal to read in its own time. And the last point I'll make, and I'll stop, is that using platforms such as Opus 2 and the other similar platforms, you can also now create electronic montages for the tribunal. So while you're speaking to the tribunal or while you're cross-examining a witness, you can bring up multiple documents at the same time and put them next to each other on screen. And the Opus operator will do that for you. And actually, you can then present and you can cross-examine in a way that physically wasn't really possible before. So the moral of all of this is that we need to understand the available technology fully and then reconceptualize and rethink the way that we behave as advocates.
Thanks so much, Toby. And the next topic we have is online hearings. And I have been keeping you waiting for so long, Yoshimi, and now I turn to you and acknowledging that online hearings are here to stay, but recognizing also that COVID restrictions have been lifted in many jurisdictions. What do you think is the state of play in terms of the conduct of online hearings, and how has practice regarding online hearings evolved? Please.
Thank you very much, Takashima-san, for kind introduction. And I have to say, I have to express my gratitude and appreciation for MOJ and ICSID and UNCITRAL to organize this fantastic event again in Japan, and this time not remotely, physically. So we actually had a private session proceeding to this official panel session. I keep the, Chatham House rules. I'm not going to disclose what had been discussed, but we had a stock taking within the small group as to how often you actually use remote hearing after COVID restriction has been lifted. Year 2022, earlier this year, we still had a COVID restrictions, travel restrictions, but nowadays it had been removed in many jurisdictions. And the result of the stock taking within the small group is out of 6 practitioners, only 1 had remote hearing after, travel restrictions were lifted. That demonstrates how, we actually went back to the previous practice, which has been somewhat criticized by, Toby Landor, but we are, I guess most of us prefer to have physical hearing. Why? Everyone knows the answer. We prefer to get together physically, just we have, physical, conference. And also in remote hearing, there are a number of technical issues. Potentially proceeding could be disrupted. And also it's notorious, people are concerned about the Zoom fatigue. So hearing could be cut short when we conduct remote hearing. And for counsel, we complained about cross-examination has been being hampered. And most importantly, is, in the remote setting, nonverbal cues are missing in most of cases. So it's really hard to read arbitrators' mind. It's always hard, but it is harder when we conduct hearing remotely. So to directly respond to your questions, I guess majority, even not most, of the hearing now
becoming physical. But what we learned during the COVID restriction actually survives the COVID period, COVID pandemic, which means some people, well, arbitration practitioners are now actively using this remote hearing technology in various ways. First, small claim, when cost and time doesn't justify physical hearing. Parties, actively choose remote hearing. And also even the stake is large when this issue in the specific here is simple and specific. Parties may agree to conduct a hearing remotely. For example, ICSID annulment proceedings. One of the issues often come up is whether state enforcement should continue. And the hearing for state enforcement, hearing that deals with the issue of state enforcement, whether to continue to state enforcement, it usually takes, less than a day or just a couple of hours. What's the, use of having physical hearing when the issue is so simple and the time for hearing is short? So even the stake is large when the specific issue is specific. Parties now actively choose remote hearing for the sake of time and cost. And also it is greener. So I should pause here.
Thanks so much, Yoshimi. And as you mentioned in our closed session, at least one practitioner had the experience of having online hearings. So it does seem that online hearings exist. And so there may be instances where parties may disagree in terms of conduct of online hearings, like one might insist on online and the other insisting on physical. And in such situations, how do you think that arbitral tribunals achieve fairness between the parties?
Right. Thank you, Takashima-san, for thoughtful question. In fact, when we had no choice but to conduct hearing remotely, arbitration community is dealt with this issue, means, whether remote hearing, whether we should conduct remote hearing when parties are not agree on having remote hearing. What about the impact of enforceability of award when parties are disagreeing to hold a remote hearing? And based on the tribunal decision, the tribunal just proceeded to conduct a hearing remotely. And on that point, I just want to introduce ICA report, which is entitled, "Does the right to physical hearing exist in international arbitration?" For the sake of transparency, I'm part of this project, so I'm promoting the project. But this report is very, very helpful to give a guidance to the tribunal when parties are unable to agree on remote hearing, or even parties agree on the remote hearing. Some jurisdiction may not actually enforce the award when award comes out of remote hearing. Award is issued, rendered based on remote hearing. This report put together by ICA, the report was launched on September 21st, 2022. It was organized by Giacomo and James and Yasmin, very highly respected arbitrators and academic. And this report covers the research result as to whether right of physical hearing exists in international arbitration in 78 New York Convention jurisdictions. And great news is that there is no reported case in which an award has been vacated solely on the basis of hearing being held remotely. That is really encouraging to promote remote hearing. But at the same time, there are cases which vacated award based, which was issued based on remote hearing, but those cases took into account not only the remote hearing, the fact that hearing was conducted remotely, but other factors that these studies that relates to the point Takashima-san pointed out, which is whether parties were equally treated, whether parties have an opportunity to present a case in equally, particularly when one party has technological challenges, while one parties have an ability to get together in one venue, while the other parties have no luxury of counsel getting together in the same conference room. Does it create an equal opportunity for parties to present their cases? So these issues are very fact specific. In fact, I think, in most jurisdictions in 2022, when most jurisdictions lifted the travel restrictions, now parties have an option whether to have remote hearing or physical hearing, which makes tribunal even more difficult to decide to hold a remote hearing without agreement between the parties. So we hope to see more accumulation of cases, which will give us better guidance as to how tribunal should deal with this issue, what really makes the party given an equal opportunity to present a case. For example, in some jurisdictions like China, China still have COVID restriction, which have been relaxed, but still they have much onerous travel restrictions, whereas compared to many other jurisdictions, how should we treat Chinese party and non-Chinese party equally? If Chinese parties say, no, it's too much to travel to hearing facility, why can't we conduct remote hearing? Should we respect it? Should we respect such one party's specific, travel restriction condition? Another point that we made when what the tribunal may encounter is carbon neutral policy of party. Some party may have adopted very strict carbon neutral policy, and they discourage company members or outside council to travel, because that will worsen the carbon footprint of the company. And should tribunal respect such companies' policy? So these multiple factors, which is some of them are new now after many COVID restrictions, travel restrictions have been lifted, put on the table, and we hope to see again, more cases to be issues to give us guidance as to how we should deal with this very complicated issue. Thank you.
Thank you so much, Yoshimi. And I know you're involved in ICA work, but now you're involved in UNCITRAL work. And so I now would like to finally ask this question to you. What do you think UNCITRAL can do to contribute to practice regarding online hearings?
Thank you, Takashima-san. I think, UNCITRAL is a uniquely situated to encourage the use of technology to save time and cost, to provide more options without concern of potential, challenge against the award, which are issued after the, hearing being conducted remotely. For example, talking about protocol of remote hearing, when this remote hearing was introduced in 2020, after lockdown was introduced in many jurisdictions, prominent institutions issued a number of prominent institutions issued remote hearing guidelines, protocols. And essentially, these protocols are the same. They address how to maintain the integrity of remote hearing and maintain the equal treatment of the parties. But what UNCITRAL can do more is to review these, various protocols, to either endorse these protocols or issue protocols by UNCITRAL, taking account jurisdictions under jurisdictions having different technological background, technological circumstances. Most of the advanced, developed countries, perhaps, technological challenges are much less, but, member state of UNCITRAL, perhaps, they have more technical challenges. Then perhaps UNCITRAL may also want to create the level playing field for those member states and user of those member states by issuing additional, protocol tailoring, taking into account those different circumstances in different jurisdictions. That's number one. And number two, compared to electronic award, perhaps arbitral award, perhaps, concern over the enforceability of award, which was issued through remote hearing is much less, perhaps, but still, UNCITRAL can, provide or encourage member states to explicitly confirm that an award will not be invalidated or annulled simply because award was issued based on remote hearing. So there are a number of things that UNCITRAL can do to promote the use of remote hearing and at the same time ensure the equality of parties. Thank you.
Thanks so much, Yoshimi, and we're very encouraged to hear that we have work to do. And yes, and I'm going now to the final topic about AI and the decision making. We are already running a little bit over time and intruding into online mediation panel. But before we start discussing AI and the decision making, let me ask Yoshimi once again this question that is relevant with or without the use of AI. What are the potentials of making awards publicly available by storing and disseminating information using electronic databases? Please.
Right. I'm mindful of time, so I make my remarks very short. Nowadays, the transparency international arbitration has been focused, and institutions now publishing award, sanitized award, and also some, company vendor compiled a database collecting those arbitral award. Now, many arbitrators, I guess, when they issue award, they are only thinking about, settling dispute between the parties without thinking that they are creating rule. In a case, in a common law jurisdiction, court decisions actually is the part of the law, but perhaps arbitrator for years haven't really thought about, given particular inference to the law in particular jurisdiction. Put it differently, arbitrators didn't play a role of rulemaking for years. But now that award is becoming more available, publicly available, and parties may start to refer to awards as legal authorities, and because company vendors put together, create a database of award, when AI comes in and AI will take into account those awards in coming to conclusion, this award could be part of the rulemaking process, and arbitration should be well aware of that potential legal implication that they are emerging. Thank you.
Hey, thanks so much, Yoshimi, and for making this perfect segue into my question to Maud. So Maud, where are we in terms of AI-assisted decision-making or AI decision-making, please?
Well, I think we're not that far yet in terms of arbitral decision-making, by which I mean the use of AI by arbitral tribunals. But, and this ties in with what Toby called the fundamental disbalance between what is done by counsel and what is done by arbitral tribunals. There are a lot of things, of course, that are going on in terms of development and deployment of legal AI. And actually on the graph that I hope that you can see right now, I made an attempt to show what's going on and draw what's going on right now and drawing parallels between these developments and what could be possible in arbitration. So what I tried to show at the bottom is that AI is increasingly deployed by counsel. for instance, as part of a knowledge management strategy to cope in a time and cost efficient way with the increasing amount of complex data, which was already mentioned here. Joaquin and John already referred to some of the due diligence tools that are on there, e-discovery tools, contract review tools, and drafting tools. I also referred at the bottom to some other tools on there that are used for strategic decision making. Predictive justice or predictive analytics is the term used to refer to machine learning tools that mimic legal decision making and may be relied on to anticipate the outcome of a pending case or of an opponent's arguments. Also, and that is what I try to convey through the top right graph, is that legal analytics and prediction tools not only help counsel, but are also used as judicial automation tools by state courts and law enforcement agencies. I think everyone has heard of Compass, the risk assessment or crime mapping tool that was used in by US courts, and that actually invited a lot of criticism and skepticism because of the bias towards Black minorities that seem to be built into the algorithm. So when you look at this graph, it's not too hard to imagine, I think, that at some point AI will also find its way into arbitral decision making.
Thanks, Maud. And just to also ask another question to you, what do you think are the potentials and challenges of the use of AI in the decision making?
Well, what was said before by Toby is that arbitrators usually do not have a very extensive or do not have the same extensive resources and teams that counsel have. So mirroring where AI is now used by counsel and other decision makers, I think there could be great potential for AI in helping arbitrators, for instance, to process complex information faster and more adequately, to assess the veracity of evidentiary submissions more objectively, to do legal research more efficiently, to automate creative processes such as partially drafting terms of reference and orders more efficiently, et cetera, and perhaps at some point even help in making actual decisions. So I think that could be the potential. The challenges, there are of course plenty of challenges in terms of engineering feasibility, the availability of data that Yoshima already referred to. In terms of business viability, so will it deliver what people expect from arbitration? But also in terms of legal or user desirability. And just merely focusing on the latter, I could give you a whole list of issues that could be identified, but I have to be a little mindful of the time, so I'll only touch upon a couple. For instance, one may wonder about how the use of AI in arbitration would require that certain due process standards would have to be rethought. Think of standards of impartiality and independence. For example, rather than being alerted by a legal opinion previously issued by an arbitrator, we'll have to worry about the subsequent reuse of particular data sets or the algorithmic bias that has crept into an AI tool and that affects the outcome of an automated decision. And how this algorithmic bias may be reinforced by the automatic feedback system that is typical for machine learning AI. Another example in this context is a rise in arbitrator selection and conflict check tools, and what this does, for instance, for standards of disclosure and challenge. How does the use of such tools that imply a thorough check still leave room for raising certain conflicts that the AI should have signaled, and how does this affect the duty of disclosure by the arbitrators, for instance? There are also some interesting questions that have to do with how AI may transform the triads party autonomy, efficiency, and due process, which is fundamental in arbitration. For instance, think of the situation where an arbitrator wants to use text mining AI to search, highlight, and extract relevant content for analysis. Should an arbitrator obtain the party's consent to use this AI tool? In other words, does this belong to the realm of party autonomy? Or is it considered a regular legal tool unless parties opt out? Or is the duty to conduct arbitration efficiently taking over here? And would this imply an obligation to use AI if that increases the speed of the decision-making process and guarantees a more objective or more accurate decision? Also, an arbitration or an arbitrator's potential use of research, prediction, and automation tools. How does this square with due process? And will this add a new dimension, for instance, to the Jura-Novit arbiter discussion and turn this discussion in favor of the argument that an arbitrator should have full freedom to investigate beyond the parties' arguments and pleadings as to the contents of the law? I could go on, but I'll stick to this right now, and I would be happy to send anyone who's interested my thoughts or papers on this.
Right. Thanks so much, Maud. And I am the first to take that generous offer to request a paper. And
Sure.
Yes. And let me finally ask this question, and I ask you to be very brief. What do you think safeguards that are needed in applying these means in terms of IAI?
Well, I think if we purely look at the legal challenges, I think that we need to explore them further, first of all, and identify what the conflicts are that may arise between the potential use of AI for decision-making and current procedural arbitration law, and also ask the question whether the current legal framework is still adequate to deal with potentially new issues that may arise as a result of the use of AI for arbitral decision-making. And I think we have to start reflecting on what the law should look like in that case. And also very importantly, I think we need to look at these questions from the meta perspective of the normative framework in which we want to conduct our arbitrations and ask ourselves the question how relevant we still find certain requirements. Due process has always been an important anchor point and a foremost internal standard making up the normative framework of arbitration. But there are, of course, also a number of external standards, confidentiality, speed, cost, which makes people choose for arbitration. And it will be important, in my view, to weigh these standards and make up our minds how they should be weighed in light of the use of new technologies such as AI. And ideally, and this is the last thing I'm going to say, this should be done through interdisciplinary debate. So we, at least as lawyers, know what we're dealing with in terms of potential and technical limits of AI.
Thanks so much, Maud. And this completes our discussion about the use of technology in arbitration. But I understand that, Maud, you have signaled that you have something to share with us at the very end. And I was hoping to ask this simple question to all of the panel speakers, but because of the time we have remaining, I would just like to ask Maud, how do you see the future of technology used in dispute resolution? Please.
Well, if I may just show you what I've done, because I was anticipating this question, of course. I asked GPT Chat the question, can you make an epigram on the future of technology and arbitration? Actually, I first asked for a sonnet, but that was too long. So I asked for an epigram, and the chat told me, sure, here's an epigram of the future of technology and arbitration, and I'll read it out to you. In the future, technology will reign. In the field of arbitration, it will gain the power to streamline and automate and ensure that justice is never too late. I don't know if it's a good prediction, but it does show that what was science fiction 2 years ago has become reality, and the future of arbitration should be one in which we are prepared for disruption and change. So on this note, I'll end my contribution.
Thanks so much, Maud. And thanks to all the other panel one speakers, and a big physical round of applause and an online round of applause. I am tempted to go straight to panel 2, but actually I have been requested by the interpreters that they need a 1 or 2 minute break to get themselves refreshed and get a break. So we'll do the same. And we'll be resuming in 1 or 2 minutes so the session will be open while we wait. So distinguished speakers, panelists, guests, we will resume session 1, and we will be proceeding with panel 2. With my apologies for the bad handling of the time, but the discussions in the first panel was interesting, and so very interesting. And so I am sure that we will have the same interesting discussions with distinguished panelists for panel 2. We have highly experienced professionals to discuss online mediation to share this, who have kindly offered to share their thoughts and insights. The speakers we have for panel 2 are Dr. Andrea Hartmann-Peradol, CEO, Consensus GmbH, and the International Mediation Campus and Mediator, Ms. Anne-Karine Grill, Principal of AKG Advisory, Mr. Jeff Sharp, Commercial Mediator, and Mr. James Claxton, Professor of Law with Waseda University. Let us begin with the basics. Jeff, what kind of video conferencing platform do you use? And aside from audio and visual that we are already using for this gathering, what functions of video conferencing platforms are essential to online mediation? Please, Jeff, you have the floor.
Thank you very much. Lovely to be joining you from down here in New Zealand. Just before I go to the platform, I do think audio and visual are really important. And of those, audio is by far the most important when we are online mediating. So I would encourage everybody to, at the very least, have good audio and video. But if you're going to have to choose one, have good audio. The other pieces outside the platform are lights, and I have a big gaming screen, so my grandkids get on my screen far too often, but I have a big 40-something inch curved screen where I can have 20 or 30 people on at one time and have a good visibility of each of them. But my preferred platform is Zoom, and I think in the commercial mediation world, that's the default. It's intuitive, I think. It's as I say, the market pick. And the reasons I like it are the obvious ones. It has very, very good breakout rooms. We can name them. I usually set them up with party names. If I've got 4 parties, I'll set up 15 breakout rooms so we can have any number of different iterations of people in each room, and it's really helpful. The whiteboard feature is great. I don't use the native Zoom whiteboard. I twin that with my Remarkable, which is a digital notepad, which is fantastic. So I use my Remarkable as the whiteboard, and then share screen. So breakout rooms, whiteboard, and share screen are why I choose to use Zoom. And it's funny, we are in commercial mediation, we often don't refer to the documents very much in a physical mediation. But when we're online, we will share screen, share documents, and in particular share photographs a lot more than we would in person. And that's an interesting cultural adaptation, but it's very helpful. So just like the arbitrators were saying, it's very helpful to have photos, etc., up on the screen. So the Zoom is good, and I think most people are familiar with it. So that's what I use. Can I just mention some add-ons to Zoom that really make it world-class? I use a background noise suppressor app called Crisp, and that I find blocks out sirens, babies crying, dogs barking. Just to give you an example, it may not work. I hope it does. But if I don't know if you can hear that.
No, we didn't hear that.
Yeah, good. So it really blocks out all background noise, which is helpful when you're attending a mediation in a less than ideal environment. And it also learns your voice, so that not only will it block out extraneous noises, it will block out other voices that are not yours. So it's a fantastic little app. The other thing I use with Zoom is a thing called PlexiCam. That is a transparent surgical plastic that hangs down from the top of my computer screen, allows me to look straight into the camera with the screen behind it, and I can see the screen behind it. That's really important for a mediator, and I think eye contact is absolutely vital, and we can lose it if we're not careful online. So I use PlexiCam. It's a little Californian startup that makes a fantastic product. The only other things I'll mention, then others will have used. We use WhatsApp a lot in mediation for a second channel of communication. I normally disable the Zoom chat and have WhatsApp groups with each council and parties. So I might have 4 WhatsApp groups, and we communicate off platform a lot, not only on procedural matters, but also on substantive matters. I like to tell parties why I'm taking so long in one private room, and I'll just WhatsApp them and say, look, I'll be another 10 minutes, but it's worth the wait. So those are my highlights.
Thanks so much, Jeff. And I also would like to now turn to Anne-Karine on the same question. I just want to quickly familiarize and have all the speakers engaged as quickly as possible as compared to what I did with the arbitration session previously. So please.
Thank you very much. I'm also very happy to be here. Good to see everyone. One thing that I would like to highlight in the given context is that confidentiality in mediation is really paramount. It is the one cornerstone of allowing us mediators to really, bring the parties to open up and to really touch upon the sticky issues. And this is really paramount if you want to get to a solution together with the parties. So confidentiality and privacy and security are really aspects of the online mediation process that we must not lose sight of. So this is really also one aspect that should go into that process of deciding together with the parties which tool they want to use, which platform they want to work on. And as Jeff has already mentioned, I believe it's really a fact that mediators like to work with Zoom for all the reasons that he has pointed out already. And in terms of confidentiality, I feel like we are in a safe space also on Zoom. So occasions where people would enter meeting rooms that are not invited, that rarely happens. And this is really a big confidence building aspect of the Zoom platform. So in my experience, what's really important is to address the issue of what platform you want to use very openly at the beginning of the process and have an agreement with the parties. Another aspect in this regard is probably the recording of the session. Some parties want it. Other parties don't care about it so much. So whenever the mediator is requested to circulate a summary protocol of the session, recordings can be very helpful in this regard. And you would have to be transparent to tell your parties that you're recording it for your own benefit, but that it will not be shared. Also, to keep in check the potential for abuse of the confidentiality aspect in mediation. I think that would be my additional comment here. Thank you.
Thanks so much, Anne-Karine. And I'd now like to turn to Andrea. Would you like to add anything to what has been said by the previous speakers, please?
Yes, first of all, thank you. I'm very happy and grateful to be here with you virtually in Tokyo. Hello from Europe, Italy. Yeah, I want to add something about the access of the tools, because as my colleagues have already said, Zoom is a very, I would say, easy to handle tool. Everybody now after COVID knows it. There is some restriction to it, and that is if we work with companies in workplace mediations, for example, there are often internal settings and firewalls that doesn't allow to use Zoom, and then we need to be flexible to switch to other platforms. And there are two aspects again on this. There are other platforms that companies use in work in remote work, but sometimes the parties feel not that comfortable to actually do a mediation in the same room they work, even if it's virtually. That's a very interesting aspect. When we talk about on-site mediation, and it is, for example, in workplaces, we also discuss with the parties very deeply on where should this mediation take place. Should it take place in your company, in your rooms, or would you go to another venue, to a hotel, or to my office, for example? And interesting enough, I have seen that now more and more that employees, for example, in workplace mediation said, I don't feel comfortable. We talk all the day about in Teams, in Skype, I don't know. Can we have another platform, please? And then I'm trying to provide platforms that are, or even talk to the IT of the restrictive companies to find a way to give them another room to mediate. So this is about the restrictions, a bit the access to different platforms. And then, of course, there is also an access if we look at it globally. For example, there are countries, we work a lot in Iran, for example, with mediations actually, and they do not have access to Zoom as it is an American platform and it is restricted. And there it works sometimes over VPN, but there are other creative solutions necessary.
Thanks so much, Andrea. And now I have a question that I would like to pose to all of you, starting with James, who has not taken the floor yet. And as mediator, how do you prepare with the parties to foster a common understanding on the conduct of online mediation, and what needs to be agreed upon with or understood by the parties to conduct mediation online? Please, James.
Well, first of all, thank you very much to the Ministry of Justice, to UNCITRAL, and to ICSID for including me today. It's great to be here. I think in terms of how to prepare the parties and to give them an understanding, the simple answer is two main things can be done. One is to provide a protocol to the parties in writing ahead of time, which sets out the process and highlights the expectations the mediator has for the parties, and then what the parties can expect of the mediator as well. And the other is simply to meet with the parties online. The advantage of meeting with the parties online and showing them the technology is that they can ask questions and you can respond in real time. In terms of the information to be communicated, I think there are three really important points that have already been highlighted in comments by the other speakers. The first is confidentiality. I think it's important to explain the expectations the mediator has with respect to the party, for example, about potentially recording the mediation. There would be a prohibition of recording the online mediation. So to be very clear about confidentiality, but then also to reassure the parties that as the mediator, you've taken the necessary steps to assure confidentiality on your side. The second would be simply going through the logistics of the mediation. So Jeff mentioned things like breakout rooms, whiteboards. We're all familiar with having meetings online, but some of these specific features might not be familiar to the parties in mediation. And the final opportunity I think there is in meeting with the parties or in a protocol is to address communication. So communication is fundamentally important in mediation, and communication online is, of course, different than communication in person. So I think highlighting things like being well framed in the video feed and the camera angle and the lighting and the quality of sound and the quality of the internet connection and the joining space, to have a joining space without distractions. I think it's really useful to address these points early on to maximize the process later.
Thanks so much, James. And I now turn to Jeff to ask the same question in terms of how you prepare or foster common understanding about the conduct of online mediation, please.
Yes, thanks, Takashi. I agree with James. The key for online mediation is to have a tech rehearsal with the parties before the first joint session, joint session. And these days, parties are much more relaxed. They often know about Zoom. They may not know about breakout rooms, and you can demonstrate how that works, and they can relax around that. You can also, as James says, just check where they're meeting and what their environment is. One of the issues we are facing with online mediation is that we tend to be mediating conference rooms as opposed to single tiles like we are all here. And that comes with some issues. So when you've got 10 people down the end of a conference room with a window behind them, they are just 10 black blobs, and you can't see who's talking, you can't see the body language, etc. So that is an issue, and technology is helping us with that. There are now cameras in the conference room, cameras that can break into a number of feeds and effectively frame each participant at the conference table, frame them on Zoom like we are here. And that's a fantastic innovation, and one that I'm starting to see from well-resourced law firms, etc. And that's a Scandinavian product called NEAT, N-E-A-T, NEAT bar. And that's a very sophisticated camera that, as I say, takes each person and puts it in their own feed. So that's helped a lot. The only other thing I'd add to what James said, in preparation, having this pre-session tech rehearsal, I always like to double it as my first private caucus meeting with the parties. And that's a tremendous advantage that we didn't have pre-COVID. Parties would not meet with the mediator privately. Normally, at best, we'd have a call with the lawyer. Now I can have a tech rehearsal and it will morph itself into a, tell me a bit about the issues, let me get under the skin of this, 3 weeks out. I'd just like to do some thinking, and you can have a very good and worthwhile substantive conversation with parties, whereas pre-COVID we didn't do that. And so that's gone to the post-COVID structure of commercial mediations, which has been a tremendous advantage, and I believe it's making mediations that much better. The only other thing I say to parties by way of preparing them is, let's give ourselves permission to talk over each other for the first hour or so. Zoom has a 1 second lag. It's very easy, as we all know, to talk over each other. And I just think, just to inoculate parties, let's be generous. Let's all get into the swing of this, but it just might take us 30 minutes, an hour, just to work out the cadence of the mediation. So things like that. And I find people are very generous with each other on screen, probably more generous on screen than in person. Certainly, I think they are less likely to say inappropriate things on screen than in person. And I've heard a lot of inappropriate things in person. So for what it's worth, I think online moderates the temperature and the conversation. So thank you.
Thanks so much, Jeff. Yes, and out of curiosity, I just wish to ask very quickly because James referred to protocols and other means of how to foster common understanding with the parties. I was just curious to know how you do that, and please.
Yeah, I have those protocols up on my website, and I'm looking at them now. Mute is a habit. Frame yourself properly, etc., and people are very welcome to go to my website. Just Google my name and you'll find it. And the protocol's up there. Also in my mediation agreement, which people will know that we sign up before every mediation. For online mediations, I have a slightly different agreement that has some of these expectations in it. A strong and stable connection. An environment where you can respect the privacy of the mediation, etc., etc. So people actually sign up to those online behaviours. And I think that's very helpful because it really does cement in the expectation. The lesser protocols like, don't talk over each other, etc., I just have as a guide on my website. But the ones that are important actually go into an online mediation agreement. And I think most mediators who are operating online would have a similar process.
Thanks so much, Jeff. And I now turn to Andrea to ask how you do this preparation phase.
I want to just go with this, what you said, Jeff, about that online mediation moderates the temper of the parties. And I do feel the same. And it depends a bit on what kind of mediation you're conducting. So if it's a commercial mediation, you could probably say that this is something good. If you are in a workplace mediation, for example, where it's more about relationship and trust building and communication, there are also different things to keep in mind about that. So what I do in the beginning is with both parties to agree on a way we want to communicate with each other online. Because if you imagine a situation where there is a pretty heated and emotional workplace conflict, intercultural probably, and one person just reveals about also emotions and what has happened in the situation, and the other person switch off the camera just because, I don't know, a cat is jumping on the desk. That could be a major distraction and an interruption to the process, because you feel when you talk and you say something very emotional and suddenly the cameras are shut down, you have the feeling that the other party is not listening anymore. And things like this, I'm not ignoring as a mediator. I would stop in this moment and just ask the other party, what's going on? Where are you? Could you please switch your camera on? I would let the parties repeat, and I would discuss that in the very beginning. So my phase one, I would say, of the mediation, where you set the rules, where you talk about communication, is just different in online and in on-site mediation, because it's more about all these little things that you might feel, oh, it's okay, I switch on my camera, my sound, when can I interrupt, for example. That is also in on-site, we interrupt a lot with body language. If I want to say something, I open my mouth, I lean forward, I maybe even touch with my hand on the desk, like on the table, to the party, and so on. And how can I gently interrupt in online mediation? That's a bit different. And these are the things that I discuss a lot with parties if it comes to relationship conflicts and in workplaces, right? We're not talking about family mediation here.
If I may, do you know, Andrew, what a lot of parties often ask me, how do I politely interject? And one of the things I say from a technical point of view is use your spacebar, because spacebar mutes and unmutes you. And a lot of people don't know that, and they fumble around with their mouse looking for the unmute button. But actually, yes, that's working. So it's a handy way to interject and pop in and pop out of the conversation. And I find that very useful.
Right, thanks, Andrea, and also Jeff. And finally, Anne-Karine, would you like to share your experience about how you prepare? I think Jeff, in my follow-up question, responded that he uses protocols, but I would be curious to know about how you do this.
I have to echo pretty much everything that Jeff said. This was a very thorough description of how mediators would professionally go about arranging for online mediations. I just want to add one little aspect, and that's, you know, aside the fact that mediators need to be very proactive and really give guidance when they're running the show online, there is a slight benefit that you get as a mediator when you're mediating in an institutional setting, as opposed to ad hoc mediations where the parties approach you, excuse me, or where you are protected by some institutional rules and institutional support. And what I mean to say is that certain professional mediation services providers, and there are a number of centers around the world very well established by now, they have cyber protocols that they place at the disposal of the parties, and you as a mediator can refer the parties to those protocols or even integrate them in your mediation agreement. And that can make it slightly easier for you as a mediator. Make sure that you don't miss any important points. I mean, by now, I think everybody who's doing it regularly knows what the critical issues are. But overall, just having an institution, a professional ADR center as your sparring partner, probably also an instance where you can refer the parties to if they are, unsure of how they should do certain things. That can be a benefit, and we should not overlook that. That would be my additional point here. Other than that, everything I had so far very much resonates with me also.
Right. Thanks so much, Anne-Karin. And drawing from our wonderful conversation that we had in Vienna before I came over here to Tokyo, I learned that you also have practical experience in arbitration as well, and in which online hearings are conducted. And for that reason, I wish to also ask my next question to you, Anne-Karin, is to draw some commonalities and differences between arrangements for online mediation and online hearings, please.
Sure, happy to do that. I think in terms of commonalities, I would say that dispute resolution is a people's business. So we need to find ways of communicating effectively in both the arbitration and the mediation settings. I think the main point of difference that I would pinpoint is that the arbitral process is focused very much on the taking of evidence and the working with witnesses and experts. And you need to find an etiquette, rules of how to conduct that part of the proceeding. Mediation is a little different in that respect. It's less informal. There is no strict rule on equal treatment in the sense that you don't need to necessarily count the minutes and hours that the respective parties get in order to present their standpoint and to argue their cases. So when it comes to the issue of evidence taking and witness and expert examination, you need to be very clear in the sense of agreeing on an order in which the people you're working with are called. You need to determine connection time. You need to make sure that the people you're working with are available at the exact moment in the time schedule when you need them. You need to make sure that witnesses are virtually sequestrated so that nobody can interfere with their evidence or their statements. You need to determine how communications between witnesses appearing for one side and counsel is safeguarded. And then, of course, you also need to take into account whether you're working with interpreters or not. So that's a layer of complexity that I would say is not necessarily there in mediation settings, simply because the process is different. And this is why I would like to hint to what we've heard from colleagues so far. It's more essential, I would say, to work with technological tools to allow this rapport building, to allow this connection on a personal level that allows everybody to have an open and informed and constructive conversation about the issues at stake. So I would advocate in that sense for shifting the focus on rather that aspect instead of the formality that is required in a legal process that is about legal decision making rather than commercial decision making of the parties involved. I hope this makes sense to everybody.
Thanks so much, Anne-Karin. And I move to the next question. I think we've already heard about advantages of online mediations, and there could be possible disadvantages to that. And I wish to ask Jeff if you can share with us your views about the trade-off of the advantages and disadvantages in conducting mediation online, please, as compared to face-to-face.
Yes, sure. I'm a great fan of online mediation, as may be apparent. Mainly, I live in New Zealand, so the tyranny of distance is huge. But I do think, especially in international or cross-border mediation, online mediation has so many advantages. I mean, the first is scheduling. We can schedule online mediation so much easier and quicker than in-person mediation. We don't need to worry about travel. The week before, the week after, traveling to Singapore from all parts of the globe. And I really do think it's just so much more efficient. The second major advantage is that we are getting, and this is anecdotal, but it's something I've experienced on many occasions when I've mediated online. We are getting a better quality of decision maker coming into the mediation. So I was doing a mediation where we had Norwegian, American, and London parties with me here in Wellington, New Zealand. And most of them would just not have flown to a central point, say Hong Kong, say Singapore. But we got the senior executives, the CEO came for a couple of hours. We got the senior executives attending because it was easy for them to attend, and they could dip in and out. And we could say, could you come back when I text you, because we would like you involved in this conversation or that conversation. So the scheduling and the decision making and the quality of attendance are really the two big advantages. A lot of people talk about the disadvantage of not being able to read body language online compared to in person. But frankly, I think for me anyway, that's overblown, and that may say something about the way I mediate, but I do think it's overblown. If I'm sitting at a law firm conference table with 30 people around the table, I don't see 90% of them. But online, I can see them all. I can see the junior lawyer who's 5 chairs down, and I can keep an eye on the CEO, the principal, and I believe I get much better body language intelligence online than I do in a big, moderately sized mediation in person. I'm a tactile mediator, and I do miss the tactile nature. I'll often, Andrea was talking about touching people. I will often touch people, which can be risky in this day and age, but usually on the elbow or just to give them some reassurance. And I do miss that. And it's taken me a while to get used to the absence of that. But I do think there is a real potential for cross-border mediations to be done in this way. And what I'm finding anyway is that the resolution rate is not suffering. Clients are satisfied, they're comfortable with doing it. As I say, it's much easier for everybody, and it goes to the green bottom line. And a lot of these companies now need a green bottom line, and this speaks directly to that. They don't put 10 executives on the plane to Hong Kong. They can, it really does their budgets well. So those would be my comments.
Thanks so much, Jeff. And I'm afraid that the next panel speakers are joining you now, so I have to be extra mindful or request you to be very brief with apologies. But I now turn to Andrea. I understand that you're particularly focused on psychological perspectives. Could you share your insights?
Yes, also about the body language and the facial expressions. We have, yes, we don't see the full body. We are half human beings on the screen, but we have the facial expressions very close. And there is some research going on actually, and this is also my observation, and that is about the eye contact. It's a very funny and curious thing because we are not really do have eye contact, obviously, in a digital space. We're looking in the camera and not into each other's eyes, but it seems that we look into each other's eyes, and that seems to have a very positive effect, because if parties are in a high conflict, for example, with a lot of emotions, they tend to not look each other in the eyes. And on site, we actually try this as mediators. That is one of the milestones in mediation, when finally the parties turn to each other and not turn to the mediator and look each other in the eyes. That creates a moment of trust, a moment of commitment also to the process to find a common solution. And that is what we have in digital space from the beginning. And I feel that there is a lot of parties who would not be able at this point in the conflict to meet on site. The physical closeness is too much for them. They would rather than, like in older times when we haven't done digital mediation, go for caucuses and not have common sessions. But they tend to be okay with it if it's in a digital session and they're not sitting together in one room and they have their safe space, for example, because they log in from their homes. And so I have the feeling that there is really a high efficiency on online mediation, even not only on all these factors of not traveling and have the chance to schedule more mediations, for example, but also on relational conflicts that they could be solved in common sessions sometimes better. And so I use the online mediation sometimes as a tool. If there is either we do only online mediation, or if the emotions are very high, then I suggest even for on-site mediation, sometimes an online mediation setting in order to discuss emotions.
Thanks so much, Andrea. And I will probably have to conclude with my final question, asking James to share your survey with us, and also to add, in addition to your survey, this question: what could UNCITRAL do?
Sure, thank you. So just to add a little empirical support to what Jeff was saying. So in 2021, I did a short survey, circulated it to mediators. I asked 10 basic questions. I did it in 9 different languages, and I got about 500 responses. And I wanted to see how the shift online necessitated by COVID-19 was impacting their mediation practice and potentially mediation more generally. And I'll just say that the things that the mediators like most about mediating online are exactly the things that Jeff mentioned: cost and time efficiency, greater access to decision makers, greater flexibility. So the ability to hold a mediation not as a single event, but potentially as a series of shorter sessions. And then finally, it was reported that mediators were getting more mediations at the high end and at low end. So low quantum cases and also high quantum cases. In terms of disadvantages, perhaps unsurprisingly, 40% reported they had technical difficulties with online mediation. A large percentage of people also mentioned that they had trouble connecting, building rapport online. And then there was also a concern that the mediation online seemed like just another Zoom meeting and didn't have a sort of the special significance of a mediation in person.
And for UNCITRAL, please.
Great. Yeah, I think that there's maybe work to be done in thinking about sharing best practices. I think that mediators who have a lot of mediations probably organically do this already, but I think it would be useful for the broader mediation community to think about best practices online. Of course, in mediation, one of the great advantages is its flexibility. So there's a difficult balance to be struck between being too general, which would be unuseful, and too specific, which would drive the mediator's hand too much. But I think best practices could be taken out usefully.
Right. Thanks so much, James. And So we will conclude here with discussions about online hearings, and we give Andrea, Anne-Karine, Jeff, and James a big round of applause. So I now hand over to my colleague, Jason Lee, please.
Thank you. You have given me a very challenging task to finish a session 20 minutes earlier than expected and the time allocated to us earlier. I do have a question to our mediation panelists. I did post the question on chat, on Zoom, but I just wanted to ask, because you had mentioned some of the best practices and the conditions that actually is useful for a successful online mediation. I was wondering whether the same applies to the settlement phase, or anything that the role of the mediators has changed because the mediation became online during a settlement phase. Because I think most of the discussions was focused on the mediation process itself, and I was wondering how the settlement phase might have changed. So since James, you're here, maybe I can ask that question, and then I'll go to our panelists right afterwards.
I'll do this very quickly. In the research that I did, the settlement rates were pretty much the same, both in online mediation and in person. I didn't actually ask specific questions about the behavior of the mediation during the settlement phase, but at least in terms of the outcome, they were pretty much the same.
Great, thank you. So now we are in panel 3. We have about 25 minutes. I hope we can use 25.
10 minutes. But we have to finish at 6.
Okay, we'll try to spend about 25 to 30 minutes on dispute resolution on online platforms. And it's great that Yoshi is here, who is also chairing the ODR. In the context of the APEC context, your work on ODR is quite important. But if you follow the discussions on sessions 1 and 2, everybody was talking about using Zoom on online arbitration and Zoom on online mediation. But there is a different type of dispute resolutions, which we have used the broad term online dispute resolutions. But as you can see on our program, we also call it dispute resolutions on online platforms. Today, we have 3 speakers, Ms. Mariel Dimsey, the Secretary General of Hong Kong International Arbitration Center, Mr. Shinsuke Mori, Manager of Deloitte Tomatsu Financial Advisory, and Mr. Satoshi Tsukamoto, Attorney of the UNI Advisory, and Ms. Teresa Rodriguez de la Heras-Villarreal, Professor of Commercial Law at Carlos III University of Madrid, was actually going to share us about the practical experiences of actually operating such online platforms to resolve disputes, which may not fall under online arbitration nor online mediation. And with that, since we're running out of time, I'd like to give the floor first to Ms. Mariel Dimsey on the HKIC examples of HKIC Case Connect, some of the features that they have in the Case Connect platform, and what kind of dispute resolution proceedings Case Connect can be used to resolve disputes. So with that, Mariel, I'll give you the floor.
Thanks very much, Jason. I'm sharing my screen, correct?
Correct.
Great. Let me just start that off. Share. Okay. There we go. Can you now see my PowerPoint?
Yes, we see it large and clear.
That's wonderful. Okay, so I'll go through very quickly what HKIAC Case Connect entails. This is a product that we're very proud of. This was the first online case management system that we're aware of, launched by an international arbitration institution. It was launched in October 2021, so it's been in operation now for a good 14 months. So basically what Case Connect does, I'm just bringing that up, is provides an online case management platform from start to finish, where parties and tribunals can communicate, upload documents, and track ongoing arbitrations. Now, I should mention at this juncture that there's a couple of legal, a couple of legal implications here that you need to be aware of, which means that we are not offering a full service at this point. And this is predominantly with respect to the submission of a notice of arbitration and with respect to the rendering of the award. As many of you on this webinar may be aware, there have been in the past issues with awards that have been issued that are not wet ink signature or not wet ink signed with respect to enforcement in China. And similarly, in some jurisdictions, there is a requirement that arbitration be commenced with a hard copy document, at least under most institutional rules, until the agreement on email correspondence, or in this case, an online case management system is made. So for that reason, we essentially started after the notice of arbitration has been submitted. Basically, Case Connect functions, as one of my colleagues said to me, like a Facebook page. You've got a number of features there, and I'll show you the actual view in a moment. But first of all, you can upload documents, and you receive notifications when the files have been uploaded or changed. There is a case calendar that's available to everyone, in which you can set deadlines, reminders for deadlines, and hearing dates on a shared calendar. You also have everything in one place, but you don't just have everything in one place. You also have certain areas of the platform that are only accessible to the tribunal members, for example. So you can have an area where you could exchange draft POs, for example, or drafts of an award that would be secure and entirely separate from the parts of the platform that the parties have access to. So what we've done here is, this is one of our test cases that we show to people who are interested in the product, and where we're pleased to report that interest is growing. So as you can see here, you basically have what, for me, in my generation, looks a bit like a Facebook page. You've got the tribunal, you've got the activities, you've got a calendar on the right-hand side. You can see here that you've got all the contact details for each of the legal representatives and the clients behind them, the seat and the language, and you've got basically the latest activities. So even if you're not getting email notifications, which of course you'd be advised to do, you could come into this and see what's been uploaded and make sure you haven't missed anything along the way. One thing that we've been asked in practice is what happens if it doesn't work. Just for information, this product is provided by Thomson Reuters. We have a contract with Thomson Reuters, and when our participants sign up for Case Connect, they also sign up to the terms of use of Thomson Reuters. And fortunately, we haven't had an incident yet where it has been offline or not available. And indeed, the contract that we have with them guarantees that it's available more than 99.9% of the time, which is effectively 100% subject to the legal caveat, which I think is usual. So this is sort of the legal side of things. So we think this is a very reliable product, and there's been no issues so far, and it's spread across several servers and backup servers. Just seeing here with respect to the case management, you can also edit here procedural issues of the case rather than just the interactions with the tribunal. So things like the supplementary deposit is due, you can add that to the file. You can upload documents like the claimant's exhibits, of course. You can upload zip files and unpack them and things like that. You've got a private message service, which doesn't really get used, we've discovered, because people either make comments on public posts or they use their usual form of email communication. But this was part of the package when we signed up for it. So our ongoing review, which we do periodically, will look at the features currently available and see if they're fit for purpose. And if not, we will change them. There we go. Here's the participants in the case. You can see everyone involved. Quite useful if for whatever reason you do need updates to emails, to send something by email, which of course the case management tool is designed to avoid, but it's all listed there in case you need it. There we go. I've already discussed that. Servers are monitored 24/7. It's banking grade encryption. One thing that we found, particularly with cases involving Chinese parties, is that oftentimes Chinese parties have difficulty accessing traditional file share servers, particularly where they're powered from Europe or the US. And I won't go into the technical details because that's certainly not my strong set, but what we've got here is accessible for Chinese users, and they've reported very positively on the fact that they can access this from the mainland, the same as anyone else who's using it. So we're hoping that will also be an attractive feature to get more users involved. There we go. Sorry, I've got features here that I wasn't aware of when I was reviewing this slide. So very quickly on the process, once the parties agree, we contact you and provide an option for a demo training session. Each individual in the case management team is given access to a specifically designed Case Connects page. As I mentioned, you need to consent to the terms of use. What we usually have in practice is that one member of the team will have the access and they will manage that on one particular side. So if a law firm is representing a claimant or a respondent, that would be delegated to a particular member of the team. Here you see some examples from actual cases. My colleague Götze prepared this for me, so you can see that she's the case manager there. She's also very much involved in this project as part of its green implications in terms of not printing everything and being able to manage everything in an online way. So you can see here we've got instances about the language of the arbitration. This is here not quite an agreement on the language, but we've put it there for the record so that everyone can access it. We've got things like the additional notes. This was a particularly quick arbitration that wanted a 15-day time limit after the conclusion of the arbitration hearing for the award to be issued, and things like the rules and the seat. Here's some recent activity. You saw that on the initial slides we showed. Here, this is from an active case, of course, and you can see here just how the chronological progression of the case has proceeded. In terms of its usage, we offer Case Connect for free at the moment, and we have just extended that until the end of 2023. So if you do have a case under the HKIAC 2018 Administered Arbitration Rules, you can use this feature in your case free of charge for the next 12 months. We currently have it being used in 19 cases with 79 registered users. Obviously, we are looking to increase that. So I would simply end with, if you're interested in Case Connect as a case management tool for your HKIAC arbitrations, please get in contact with us. And I'm conscious of time, so I'll stop sharing my screen now.
Thank you, Mariel. And I know that you have to leave in about a few minutes, so I think I will just pose my question to you right away. What has been the feedback of the users? You said that they were mostly positive. Were there any negative feedbacks or that you need to improve? I just wanted to kind of see how you look forward to Case Connect being part of the HKIAC services.
So thank you very much for the question, Jason. What we're aiming for is that this is usable for everyone. So what we've seen in terms of the feedback we've gotten is a bit of a generational gap. And that is related, I'd say, more to technology generally than anything specific with our program. We do think that will change. And obviously, one of our stated objectives, particularly where we appoint, is to appoint a young, diverse group of arbitrators. And often with them, they're not the ones who are having issues with our tech, if I may say that. Having said that, of course, if there is a feature there that is confusing or something's incorrectly described, or as I said, the private messaging function, which we've seen is just not being used, we do take that on board and we will speak to Thomson Reuters periodically. And there are certain things that our IT team can, of course, change themselves. I should mention there we've got an IT team of 4 people, which for an institution of our size is quite large, and they are very much on top of ensuring that our users are happy. So no specific complaints about the features at the moment. It's more just we've had people who haven't known how to log in and haven't known where to find something. And of course, our IT team is always on standby, ready to help with those kinds of inquiries.
Great, thank you. And thank you for your time. So
you're very welcome. I'll stay on for another 10 minutes or so, but then I unfortunately have to leave. Thank you.
Great. So actually, Mariel mentioned the relationship between HKIAC and Thomson Reuters. And I think the next 2 speakers will actually be able to give us the technical support that can be given to an online platforms and how different platforms could be used by different users. So with that, I'd like to give the floor to our two speakers, Shunsuke Mori from Deloitte Matsu, if you are available, and then to Satoshi Tsukamoto from the UNI Advisory. Shunsuke, you have the floor.
Can I share my slide?
Yeah, please.
Hi, hello everyone. I'm Shunsuke Mori from Deloitte Thomas Financial Advisory. I'm in charge of ODL system development. Deloitte Thomas is providing many services for solving your company's problem. ODL is one of them. Our ODL system is named Smart Judgment, and the best feature of this is to use online chat, not video chat, only online chat. We have been offering this since 2020. As an ODL system provider, Deloitte provide ODL system to ODL service providers such as ADL Institute and e-commerce platformers. Today, here, we have a ODL service provider, UNI Advisory Service. They provide ODL service using our Smart Judgment. Mr. Tsukamoto, please introduce your companies and services.
I will explain the ODR service provided by UNI Advisory Service. UNI Advisory Service is a member of the UNI Group. UNI Group provides comprehensive services related to law, accounting, and tax centered on Uri and Itoga, a law firm. UNI Advisory Service has been certified by the Minister of Justice of Japan as a certified dispute resolution business operator. Our system and services itself can handle any type of dispute, but we have been certified that non-lawyers can act as mediators for e-commerce disputes up to 1 million Japanese yen, which are particularly suitable for easy and quick resolution using the text chat. In Japan, whether lawyers are properly involved or not is an important factor in certification. In this regard, we believe that since UNI Advisory Service is a member of a group centered on law firm, the legitimacy of the mediation was guaranteed, and we are able to receive certification. I will explain the business model of UNI Advisory Service. Our ODR service complies with the APEC collaborative framework for ODR. Customers agree to use our ODR service before purchasing something by agreeing terms of condition of e-commerce business operator. In our business model, we have agreements with the e-commerce business operator to use the platform, and fees for platform use are collected in the agreement. So the fees for using ODR service are broadly and thinly added to goods prices. Actually, our ODR service is provided only when the company that has signed the platform use agreement is the party. The parties to whom we provide services are e-commerce business operators and customers. Both can use the ODR service itself free of charge. Mr. Mori will explain again about the procedure.
Thank you, Mr. Tsukamoto. In addition, we system providers, so we plan to offer this service to other companies, such as rental housing companies or insurance companies and sharing economy companies. And smart judgment is SaaS product. The advantage of SaaS, we can provide this system to many audio service providers relatively easily. Also, clients do not need huge costs and time for initial development. We just charge monthly fee for using this system. We are compliant with the APIC collaborative framework. There are 4 stages: commencement, negotiation, mediation, and arbitration. So now I'd like to show very briefly how our audio procedure proceed. This is a login page. First, the client login to start audio. On this page, the client registers the claim. Once the claim is registered, the respondent received an email requesting joining the audio. This is the respondent's screen. When he clicks the URL in the email, he can see the details of the claim. And next, once the respondent agrees to join audio, the negotiation stage starts. The claimant and the respondent can communicate the claim using online chat. Here is how the chat goes between the parties. Like this, like this. When the parties settle the dispute by the negotiation on chat, the claimant or the respondent can make an agreement. If both of the parties agree to it, this case is settled and finished. But if one party disagrees, they can move on to mediation stage. When both the parties agree to move on to mediation stage, audio provider appoint a neutral. And once the neutral accepts the appointment, mediation stage starts. Same as the negotiation stage, each party's textbook display with different colors. After communication with the parties, the neutral make a settlement agreement. When the settlement agreement is submitted, the parties can check it on their own page. If they agree to it, the case is resolved and finished. But if one party disagrees to agreement, the case would end in unsettled. This is how our audio procedure proceeds. The whole procedure would normally take about 2 weeks. And this speedy and convenient resolution is very suitable for e-commerce dispute. That is due to the nature of online shopping, such as especially speedy and convenient, and average purchase amount is low and frequency of purchase is high. So generally, online customers do not want it to take long time. We believe the audio is very helpful and needed to e-commerce dispute. That's all. Thank you. Thank you for listening.
Thank you so much. I think the last slide actually highlights the importance of this online dispute resolution platforms, because you're focusing on a different body that we have not touched upon when we talked about online arbitration and mediations. We're focusing more on the arbitrator and the mediator and the parties and the legal representatives that are representing them. But here, there are different actors that are currently being involved. First, you're replying to the needs of the e-commerce operators, because they also need to have embedded a dispute resolution systems for their e-commerce. And then in order to do that, you have an ODR service provider, which actually provides services to the e-commerce businesses. And to service the ODR service providers, you have the ODR system providers. So you have multiple actors kind of combining their services to provide dispute resolution as a service. And I think this is something very important that we have to look into, because we're not only talking about arbitrators being the service providers and the mediators. Just on the question, we just had a general question that we were going to ask all of the speakers. My question to you, Shinsuke, Mori, and Satoshi is, how do you see these platforms changing? And if I may add one question, whether you're going to be adding anything additional to the online chat services, because you said that your services are based on online chat, but would you be foreseeing any kind of a video services for your resolution of the disputes?
For me?
Yes.
We try to develop the video chat, but it takes some time because it's very expensive for us. So I will develop
Yes, I just asked the questions. Yes, please.
Thank you. We will consider adding video for larger disputes.
I think this is just a question because a lot of the arbitration and other dispute resolution services are trying to outsource some of the technical services, to outsource them to technical companies and ODR system providers. And I think this is one of the issues that they face because they don't want to develop everything in-house and they need to have these system operators actually behind them. We mentioned Thomson Reuters for HKIC, and I guess Deloitte is doing that for UNI and for the e-commerce operators. So I think this is kind of what we need to see. And that's actually brings us to the next speaker, because we have a number of other service providers who are providing these ODR services. And I would like to pass the floor to Teresa to talk about the principles that govern the use of online platforms for dispute resolutions. I just wanted to mention that UNCITRAL has worked on ODR. We do have, and we have prepared the UNCITRAL ODR technical notes, which has been the basis for the APEC collaborative forum framework for ODR. But Teresa, what are your thoughts about the basic principles that would be governing these kind of ODR services and the actors that are engaged in providing those services? Teresa, you have the floor.
Thank you, Jay. Good morning from Italy. Good evening for all of you. I would like so much to be there in Tokyo with you. Unfortunately, on this occasion has not been possible. Thank you very much to the co-organizer, UNCITRAL, ICSID, and the Ministry of Justice. As Jay was asking, I think that is very, very important precisely to make an effort to define properly what are ODR and what are the different actors that may participate in this ODR ecosystem. And that led me to precisely start by, from an organizational point of view, show you the different actors and the different types of ODR platforms that we should take into account. Let me please share my screen. You should be already seeing my screen. Well. So the first question is definitely, what are we talking? We talk about dispute resolution platforms or dispute resolution in platform. I would like to show you that there are two different perspectives that we have to bear in mind in order to understand what is ODR, but then in order to identify properly what are the actors involved. And only then we can precisely spot the challenges and the possible principle that we can apply in order to guarantee that these dispute resolution in platforms are precisely aligned with the general principle of dispute resolution. Let me just start by showing this image. In this image, what I'm trying to describe is a platform. a platform where the first actor that we have to focus on is precisely the operator of that platform. This operator of the platform might be, first, a purely technical service provider. So it's the providers of the service, and it's purely providing a service from a technical point of view, with absolutely no interference in the dispute resolution process. The second possibility is where this operator is indeed the operator of a platform, and therefore regulate the platform, supervise the platform, and to that extent, adopt certain rules that are going to impact on how the user of that platforms carry out the specific activity. And this activity could be precisely an electronic commerce transaction or could be a dispute resolution process. So we are going closer to an operator who have an impact on the dispute resolution process. The third possibility is when the operator is indeed the facilitator of a dispute resolution process. Could be a facilitator of a negotiation, could be a mediator, could be an arbitrator. This distinction that we are drawing between a purely technical service provider and a facilitator of the dispute resolution, I have to confess that is clearly blurring when we use automated decision-making process. When the system incorporates automation, the distinction between what is the real role of the operator clear is not so easy to make. And that probably raised one of the main challenges that we are going to discuss. Within the platform, we may have a specific dispute resolution proceeding. So each case, each mediation case, each arbitration case, or in general, each ODR case is going to give us another small ecosystem with different actors within the platform. So if we combine the two perspectives, we have a macro platform that might be a platform designed for dispute resolution, and then we have within the platform a specific ODR or online dispute resolution proceeding. If we take a look at how that works in practice, we see, for example, as has been explained by the previous speakers, we could see, for example, a platform that is not an ODR platform, but an e-commerce platform that include a specific dispute resolution mechanism, for example, for the purpose of content moderation, for handling the complaints, indeed, for solving dispute between the seller and the buyer. And that is very important because that leads us to understand what is indeed the scope and the extent of recognition of this kind of decision, and what is going to be the enforceability of this kind of decision. Are we only assuming the recognition and the enforceability of this decision within the platform, and probably essentially based on the contract? So it's a contract-based recognition and enforceability, or we can also, and we indeed aspired to guarantee an outside the platform enforceability and recognition of this kind of decision. That is going to be definitely a very important challenge. And in my opinion, that is going to depend very much on the principle that this platform comply with. What are the challenges? The first challenge is definitely the platform governance. And we have here three problems. The first one is, depending on the organizational model followed by the platform, we have a challenge related to how to guarantee impartiality. We have platforms that are purely technical. So, for example, the case that has been discussed before, Deloitte or any other private sector company, we could have a platform that is managed by a court, managed by a court of arbitration, managed by a totally independent third party, managed by a technical service provider. The second question about impartiality is who is going to adopt the internal policy of the platform, and to which extent these policies that are contract-based are going to become the procedural rules of the different ODR proceedings that are going to take place inside the platform. And finally, what is going to be the applicable law? In many platforms, the applicable law is not the national law, it's going to be the law of the platform. So again, We have a dispute resolution mechanism that is adopting a decision on the basis of the law of the platform, that is indeed contractual law. The second challenge is the access to the platform. So how the identity of the parties is going to verify? Are we going to use, as the UNCITRAL has already concluded, are we going to use on digital identity, mutually recognized? Are we going to use simply as opening an account as we can do in any social network or any platform? Is indeed the identity properly verified? How the data, the personal data, are going to be protected? To which extent the platform is going to guarantee the confidentiality of all the relevant data within, for example, the ODR proceeding? And how we're going to guarantee valid consent? Is sufficient to open an account in a platform in order to express a valid consent for any dispute resolution proceeding that is going to be started and completed within the platform? And the third challenge is, are these platforms guaranteeing appeal mechanism in order to appeal, question, or challenge the decision within the platform? And who is going to be in charge of that appeal? The operator of the platform? Is the operator of the platform impartial and neutral in order to adopt this appeal decision subsequently? Let me just conclude, Jay, with, if I may, in a minute, trying to offer you what are, in my opinion, the main principles that we should guarantee in order to face effectively these challenges. Definitely, we need to guarantee a principle of accessibility. And we have to be sure that accessibility is complemented by confidentiality and equality of arms. Is the only way to ensure that we are indeed close enough to a dispute resolution, general dispute resolution principle. But to the extent that many of these, as has been explained before, platform incorporate to a certain extent automation, we have to guarantee additional principle. In my opinion, at least three: explainability, right to a reasoned decision, and judicial or at least human review. So what that means essentially, let me just conclude in 30 seconds. What that means essentially, if we use automated decision making and any of the stages throughout this ODR is fully automated, we need to guarantee, in order to, for example, allow subsequently an appeal and therefore access to justice by the affected person, we need explainability of the process. So the affected person needs to have sufficient ground and reason to understand why this system, for example, this particular stage has adopted a specific decision, why this particular suggestion has been not accepted, why a specific request has been refused. So in a way, we need to guarantee that automation is not an excuse to produce arbitrary, unreasoned, or unfounded decision that in a way would undermine significantly the access to justice. Let me conclude here, Jay, and I'm very happy to discuss any further if we have time. Thank you very much.
Thank you. I think you've highlighted that there are very many different issues that we need to discuss in the context of ODR. Yes. One thing that I do want to mention is that we did talk about certification that was mentioned by Shunsuke in that process. And I think that's one of the approaches that APEC has taken with regard to certification of certain ODR service providers and actually providing some sort of a guarantee that the service provided by the services are something to be guaranteed. So that's a regulatory approach. We also need to take a taxonomy approach about what we mean by the different aspects. I think that's something that Teresa has highlighted. The more and more I think about it, I think recognition and enforceability should be a basic function of the ODR mechanisms and not be part of a separate mechanisms. And I think there is a trend towards that way. So let's think about it. This is definitely something to look into in the DRD project, in the stocktaking. These are areas where we see a lot of developments, and we hope to see and rely on the actual practices that is being developed by the service providers and academics like you, Teresa. Thank you for your contribution.
Thank you very much.
Since we're running out of time, I would like to give the floor for the closing remarks to Mr. Takeshi to give the closing remarks.
Good evening, good afternoon, and good morning, depending on your time zone. I am Matsumoto Takeshi, Director of the Ministry's Secretariat, International Affairs Division of the Japanese Ministry of Justice. I have the pleasure to address the closing of this session. I will be brief. I would like to begin by extending my sincere gratitude to all the speakers and moderators for their valuable contributions and to the participants for following the discussions with interest. My special thanks go to Ms. Anna Jovanpre, the Secretary of UNCITRAL, for leading our endeavors together in making this session successfully take shape. In this session, we have had fruitful exchanges on various matters relating to the use of technology in arbitration proceedings, online mediation, and dispute resolution on online platforms. We hope that the excellent interventions and presentations made today will assist the UNCITRAL Secretariat's effort in compiling, analyzing, and sharing relevant information, and that they will give impetus to the discussions to take place in other parts of the world in the lead up to the Commission session in July 2023. We look forward to the note by which the UNCITRAL Secretariat will be reporting to the Commission, reflecting the discussions that took place today. By extending my sincere thanks to everyone once again, and my best wishes, I conclude my closing remarks. Thank you very much.
With this, we conclude session 1. Due to the next booking of this room, we have to leave here immediately. Thank you for your cooperation. Thank you.